Good evening to all.
Good evening, Mr. Vivek.
Good evening, Ms. Fabienne.
Mr. Vivek is going to compare our first session. Mr. Vivek is one of the leading lawyers from Delhi, and he's also a biomac trained mediator working from Delhi.
Good. It's a pleasure and an honor to be here. Am I on good time? Am I in good session? I have not made a mistake.
No,
I think you will thoroughly enjoy the session because there are a host of people who are there, means an international expert on mediation, and of course led by Thiru sir. He has one of the charming chap in mediation area in India. And then Shiv Kumar sir is also there right now. Good evening, sir.
Okay. I have here just to make sure that I listen, that I hear correctly. Okay.
Oh, I hope I'm audible to you.
Yes, now I'm listening. Now I'm hearing. I didn't hear correctly until now. Sorry, I had some little technical problems.
No worries, means this is why we have logged in some time before so that we could just omit those problems which can be possible.
Good. Okay.
Yeah.
So I see here Thiru, and I have the pleasure to meet here the team BIMAC, Mr. Vivek Narayan Sharma. You are speaking there.
yeah, Ms. Sharma is there, and then Ramya and Manik will be joining. And Siri is another team. Siri, are you logged in?
Siri Prasad, yeah, I see him also on this page.
Yeah, yes.
That's perfect. Yeah,
Siri, she's going to compare one of the other sessions today. And Ramya is going to compare the second session, Siri the third, and then another young lady called Akila, the fourth session as such.
Good, perfect.
We want to engage all young mediators to be part of the program, to encourage, so that they are the future generation. They need to take over mediation to a higher level.
Yeah, exactly. Well, this is also the message that I will bring when I will replace Kimberly by the slides that I have just sent to you. This is also online is our future, and our future is the young people coming. So yes, indeed, you're right, Thiru. I share your view here. I see. So Thiru, I will not present Kimberly, because she's not coming and we do not have the video. So this is certain.
Yeah, I tried calling her. I think she was in the flight. She cut my call, but I don't know whether she has landed or not. Maybe she thought she'll come in time. Let's see. I doubt she'll come now because
now anyway it's too late. We will not. We will say that we had to adapt also ourselves. So
yeah.
You have received my my also slide to replace her. Hello, Ramya. This is we see you. Welcome.
Thank you. It's wonderful to meet you.
Great to see you also. I just would like to make a test to make sure that I may make my slides. Yeah. So I will just open them already. I will open the slides. Yes.
It should be made a co-host.
You've been made co-host, so it should be easy for you to share the slides.
Yeah, it's open here. So may I just try to make I make a try. I make partager yes now. And it works, I guess, huh?
Yes.
Yeah, it's working. Perfect.
Okay, perfect. So now I close it, and that's it.
Hi, Lino.
Good evening, Mr. Pasquale Orrico.
Hello, Pasquale. Do you hear us? He's coming. He's making perfect.
Good evening, Mr. Pasquale Orrico.
Pasquale, do you hear us? Does not hear us. Do you hear us? Can you make a...
Lino, you need to unmute your audio. Can you hear me?
we do not hear you. Gérard, est-ce que tu nous entends?
Oui, I hear you correctly. Fine. Do you hear me?
Yes, we hear you perfectly, but we have a problem with Lino. Lino,
can you hear me
Good
now?
evening,
oh, yes,
Mr.
yes.
Okay.
Mr. Gérard Kuyper?
Hi.
Yes.
So how would you like to be pronounced? Kuyper Gérard or Gérard Kuyper? Because I got both the names in this
That's fine for me. Gérard is my first name. Yeah, indeed. And my name is Kuyper. But Gérard, if you prefer, Gérard is fine.
Very well.
And Pasquale, do you prefer Pasquale Lino or Pasquale?
Maybe both is the correct one. Pasquale Lino is okay.
Good.
Lino?
But Lino is preferred. Yes.
Good.
I prefer
So
Lino.
perhaps I will jump from one to each other.
It's shorter.
And also, Thiru, I always call you Thiru, but first I would like to see the correct name. Do I say correctly, Mr. BC Thiruvengadam?
Absolutely. Perfect.
Good, because I have never called you Mr. BC Thiruvengadam.
If people find it difficult, they all, I tell my friends, break my name into three. One is Thiru, then Weng. It sounds like something Chinese, and Adam. Thiru, Weng, Adam.
Good. This is great. So, my friends, you have seen that we had to adapt ourselves because of the problems with Kimberly. She could not join us with the video. So I will jump the last speaker and I will adapt my time in view of the previous slides that has been handled, okay? So let's do it. We will adapt ourselves.
Sure.
But just for time business, I just would like to make sure. So we have we have 80 minutes. That is from noon 30 to 1:50, correct? For us in Europe.
Yeah.
Okay. Do I have? How do we handle the end of the session? Do I have to say now we are finished? It's finished. Goodbye, or
yeah, you do that. Yeah, once you end this session, then Vivek will have a couple of words to say, and then we break for the next session. There's a short break. Then they go into the second session after 5 or 10 minutes break, what we call as a wellness break. We follow this wellness break to ensure that all the participants do not have a strain watching the monitor, and then they can.
Okay, so when I see the time arriving, Thiru, when I see that for me 1:50 p.m. is coming, yeah. I little to little say, oh, so now we have finalized our first session, and I give the floor to you, Thiru, to handle.
To Vivek. Vivek will take over again.
To Vivek. Okay, Vivek. Well, then do not hesitate to jump into the session in case I do not do this correctly, okay?
Surely.
Good. Vivek, then I vote. Okay. So I will certainly say at the end, I give the floor to Vivek to handle. I don't know for you in your country, but here it is raining like crazy. So I'm very great here in front of you in my house.
Today we have a blue sky. Looks like to be in the Dolomites. But
in Belgium we have we will have rain in the afternoon. So it's sunny at this time, but we expect to have rain, a lot of rain in the afternoon, just after Paris.
I expect
I offer you my rain
in London. It's nice to share the screen with Belgium and French.
Yeah.
Hi, Sirik. I see you there. Can you hear us? Can you hear me? Is the audio working well? Not really. Maybe you have to log in again.
Yeah.
For the benefit of Lino and Gérard, Vivek and Siri are young mediators of BIMAC. So they're going to lead every session, lead the speakers here. And now we have a very veteran friend, very great friend and supporter of BIMAC. Part of BIMAC is Mr. Kumar. He's one of the best mediator trainer in Bangalore or in India.
Well, it's a pleasure. It is an honor to lead so many people. Great.
And Akila has joined too.
Good.
So this team BIMAC, you have Manik also, and along with Ramya, the young brigade of BIMAC.
We feel surrounded now. That's great. Secured.
Wonderful.
We can't escape.
Yeah. Now we are here. Stop now.
Siri, have you checked your audio?
Yes, Siri, we do not
Akila,
hear you.
Can you check your audio?
I just want to check if I'm audible.
Yep, you're audible clearly.
Thank you, sir.
We'll start sharp at 4 p.m. India time.
Yeah, in 5 minutes now.
Yeah. Yesterday's inaugural went off well. I'm not sure how many of you had watched it. It went on a clockwise precision at exactly 55 minutes. We closed the session. Our Supreme Court judge gave an excellent speech on mediation, social justice in mediation. It's been put up in the website of that is the YouTube of BIMAC.
When it begins sharp, it's Vivek who's going to begin to speak.
Yes.
Okay, good.
So I will take 2-3 minutes, 3 minutes precisely to finish my beginning. And then I will turn it over to you, Ms. Fabienne.
Yeah.
And then you can take over.
Yes.
And then I will enter the bridge in the last.
I will be the last one.
It sounds like a launch rocket.
Like a what?
Yeah,
a rocket launch.
Rocket launch.
No, we are just trying to be precise.
Lawyers always have the last word, Vivek. Remember that?
Yes, sir. Well, there is a famous dialogue. Law is a precise endeavor.
Yeah. And Vivek, incidentally, is joined us from Delhi. Siri is from Bangalore, and Akila is from Chennai.
Okay.
Is my voice clear now?
How many participants are there?
At this time, I see 48 people.
Great.
So you're not audible. Your mic is closed, sir.
Yeah, it's a second Saturday, which is a holiday in most of the places here. And so people have their lunch, take a nap, siesta, and they'll be a bit slow in logging in. But we have more than about 480 registrations so far. So even if you have even 1/3 of them really logging in, it's be good. Welcome, Anik.
Good evening, sir. How are you? Good evening, everybody. Welcome.
Hello.
Hello.
Hi, Manik.
Vivek. Hello, Akhila.
Hello, everyone.
Hello.
Yeah, hello, hello. How are you?
All good. How are you all doing?
Perfect.
Nice to see you.
Yeah. So we just wanted to check how your audio works and your video so that you can, your video also works well. Good.
So it's last minute. I think
Yeah.
we should be starting soon.
Yeah.
My screen shows 4. Please prompt me, sir, when we have to start.
So it's 4 starts, sir.
Okay. Ciao, Biju, Hola, Bienvenidos, Namaste, good evening from India. I am Vivek Narayan Sharma, and I'm an advocate on record at the Supreme Court of India and a BIMAC mediator. I'm in practice for last 22 years. On behalf of Bangalore International Mediation, Arbitration and Conciliation Center, I welcome the attendees, the speakers, and the media for session 1 at the International Mediation Conference. The topic for discussion in session 1 is COVID-19 pandemic and online mediation. Before the commencement of session 1, it is my utmost pleasure to introduce you in brief the esteemed super mediators panel present here. Session 1 shall be moderated by Ms. Fabienne Vleugel. Ms. Fabienne Vleugel is working as a French lawyer admitted to practice in New York for almost 25 years and is managing her own law firm, VDV Advocates in France. She is an accredited mediator in various countries, UK, Belgium, France, Luxembourg, and is very often nominated as judicial mediator or ad hoc mediator. In her capacity as president of the UIA World Forum Mediation Centers, she has organized mediation conferences in various countries and continents. She has written articles about mediation regularly and is teaching business law as associate professor at the University of Gustave Eiffel in Meaux, France. She is very often asked to intervene as a speaker, but here she has accepted to be moderator of our first session. Warm welcome to Ms. Fabienne.
Hello. Hello to everybody, and thank you a lot for this very kind introduction. And thanks a lot for this invitation. You know,
Joining
it
with
is.
her, I will just introduce the speakers as well, please.
Okay,
so
go ahead.
Joining with her, our speakers are Ms. Pasquale, Lino, Orrico. Ms. Pasquale, Lino graduated with a law degree from University of Milan, Italy, and has been a member of the Milan Bar since 1997. His areas of practice include inheritance, real estate, domestic and international contracts, and tax law. He is a vice president of the Milan Forensic Movement. He is an accredited mediator, and actively participates in various mediation activities and associations around the world. Welcome, Mr. Lino. Our next guest speaker would be Mr. Gérard Kuyper, who is a member of Brussels Bar since 1992, an accredited mediator since 2008, is a co-founder of Altruist Law and Mediation, the first Belgian law boutique where all partners are accredited mediators. He practices commercial law. Civil law includes company, transport, and liability law. He's a certified mediator in civil and commercial matters. He chairs Business Mediation Centers of Brussels and is a director of Brussels Chambers of Commerce. Welcome, Mr. Gérard.
Thank you.
Our next speaker would be our own Mr. Mr. B C Thiruvengadam. Is a lawyer since 1983. He has degrees in commerce and law from Bangalore University and an intermediate degree in chartered accountancy. He is a patent agent of the Government of India and a certified US patent process prosecutor in Sunnyvale, California. He is a certified mediator by ISDL San Francisco and a High Court of Karnataka. As an arbitrator and mediator, he has resolved several domestic and cross-border disputes, involved in establishing several court annexed mediation centers in India, including Bangalore Mediation Center, that is BIMEC, the organizers of this conference today. He is featured in the prestigious LexisNexis 100 Legal Luminaries of India 2016, Asia Law Journal's Leading Lawyer, Legal 500, Chambers and Partners, and Asian Business Law. He is co-founder and honorary director of BIMEC. I'm sorry to miss Ms. Kimberly Schreiber, lawyer from Tennessee Bar. Somehow she had not been able to join us today because she was in flight. Her flight had not landed yet. So I hope if the time would permit and she is able to join, so we would be all very honored to hear her. But now I turn I just want to add that for detailed profiles of moderators and speakers of today's meet, please visit BIMEC's website. I now leave the floor to Ms. Fabienne. Most welcome, ma'am.
Thank you. Thank you a lot, Vivek, for those introduction of all the co-speakers that are going now to speak during this session. Yes, my role will be here only as moderator, but since our friend and colleague, mediator Kimberly, could not land yet with her plane, it is possible that I have also some words to say in order to explain the subject matter that she was also kindly invited to develop. So anyways, thanks a lot again for this invitation. All my colleagues, co-speakers are very happy and honored to be here with me. And myself, I'm speaking to you now from France. And we are very happy to be in this international event with you, all the participants, this audience. So we have here the pleasure to begin this international summit with the very first session, those with my colleague mediators. And the focus of this first session is online mediation. Online mediation has been available as a format for dispute resolution already since the 90s. During the years since then, some of our mediator colleagues began using the online format for some of their mediations. But the adoption of ODR, online mediation, has taken a number of years to even begin to gain some acceptance. Since the arrival of the pandemic throughout the world, the use of ODR has grown dramatically. This is a fact. We all noticed that. All of us in the world have been experiencing restrictions on in-person gatherings and travel restrictions. Online mediation is more and more often used. It has even become a necessity. And there is an old saying, necessity is the mother of invention. mediators all over the world need to reinvent their mediation practices in order to provide adapted services to parties in disputes. So there is a question that we must handle during this first session. How do we continue to offer mediation services during the time of the pandemic? And how do we have to adapt our practice as mediators in our respective countries? The answer to this question is in fact simple: online mediation. And today, we have the opportunity to hear from my co-speakers about their recent experiences with online mediation in their respective countries. Later, as requested by the organizers and as I said, I will make perhaps some additional words about confidentiality during online mediation. But now we will begin our little travel around the world. At first place, we will stay in India. And we will begin to listen to my friend, Mr. B C Thiruvengadam. You know, Thiru, I know him for a number of years now. He's a lawyer of over 4 decades of standing. He's a partner of Thiru, as you know. He's an internationally very known arbitrator, mediator, and also recognized by a university in the US. He has intervened very often as speaker in the UIA World Forum Mediation Center. And he will share today his knowledge, as he does when he makes a lot of trainings for the young generation and I don't know how many mediators in India, thousands of mediators are listening to his trainings. And now we have the pleasure to listen to him. Thiru, the floor is yours for the first part of this session.
Thank you, Fabienne, and thank you, Mr. Vivek, for all the generous words. Welcome to all the participants and my co-panelists from all over the world. It's wonderful to share my thoughts, a bit of my experience with respect to online mediation, which we have been practicing in the past few years. I'd like to share a few slides and talk about it. Okay. I would relate that with relation to the topic, COVID pandemic and online mediation. Well, Fabienne said, yes, online mediation has been there for several years. But COVID, unfortunately or fortunately, made online mediation as a Hobson's choice. We don't have any other choice but to go in for online mediation because physical mediation could not happen. And in India, as you see in the slide, during the first wave, as we say, that is, which happened in 2020, we have been suffering from 24th March 2020 to 2021. There were a number of total lockdowns phased over. Till end of May 20, we had a total lockdown. Then again, it went up to, there was relaxation. Again, we closed. And so there was containment zones. Certain cities were locked. It was pretty problematic as such. But in the first phase of total lockdown, that is from March 2020 to May 2020, as such, it's not 21. The movement of about 1.38 billion population got restricted totally. And as the lockdown was lifted in a phased manner, things started getting relaxed. But for various reasons, people were not willing to meet in mediation. Maybe the lawyers, maybe the parties, and including the mediators. But at the same time, what has happened was there was a compulsion. There was a little dip of mediation in the beginning, between March and April, we didn't have much mediation at all. But the lockdown, which I said, the continuous lockdown and intermittent lockdown affected the economy of India. In January, as on March 20, the GDP growth was just about 3.1%. But unfortunately, due to the pandemic, setting of pandemic, we got a negative GDP of minus 39.3%. Every sector had a negative growth. Mining, construction, hospitality. Factories were shut down, offices were shut, millions lost their job. That means no pay or no income, and rents were also not being paid. So this resulted in definitely disputes. When I say disputes, it did not flow into the court. The reason for not going to the courts is that people did not have money to litigate. Not all could do that. Big corporate, yes. Banks could. But small and medium middle income group as well as business enterprises thought twice. They did not want good money to chase bad money. Even court filing became restricted. Not many cases could be filed for the simple reason we had only virtual hearings and only emergent cases were being taken up. Many times they were discouraged in filing cases unnecessarily. And fortunately, the Supreme Court of India said, okay, because of this pandemic, we are going to extend the limitation period. That means the time given to file a case under various categories got extended automatically and said, okay, you can file it after the lockdowns are all lifted. So there was a huge dip in litigation. But there were people who wanted to resolve and go forward. Okay, they wanted to go forward. So as you see in this slide, this is from BIMAC experience. In 2019, 97% of the mediation were physical and online mediation was only 3%. In 2020, 12% was physical. That is only till March, the first 3 months. But the significant increase in online mediation became 88%. From January 2021 till end of June, or rather I can say till date, physical mediations is zero, nothing. But online mediation is totally 100%. There's a significant increase in mediation, online mediation. And I'm going to talk about this. What are the advantages of online mediation? First and foremost, with the COVID around, there's no risk of getting COVID because we are not going to meet physically. The second advantage is that we are not going to travel. We, in a sense, the parties, the lawyers, the mediators are not going to travel to a mediation center and meet physically. So the travel time gets saved. And during the lockdown, many could not travel because movement was restricted totally. In addition to it, there is considerable amount of saving time because of travel, because Bangalore is notorious for its traffic jams. So people felt, oh my God, thank God we are at home and we can do this mediation online. So they can log in from anywhere. During the pandemic, if there is a dispute, one person got stuck and maybe a person from two disputants of Bangalore, one happened to travel to Mumbai or Delhi. He got stuck there due to the lockdown. He could not come back. Still, the mediation happened because of online facility. Had it been a physical mediation, the mediation would not have happened. We would have adjourned the dispute to the resolution to some other day. when other parties were present. So login was from anywhere, or we call it as anywhere bank mediation, as they call anywhere banking. We can do anywhere mediation. And insofar as the registry is concerned, it was better case management. You don't have to have physical papers being sent, reports sent by the mediators to the registry, and getting application requisitions, everything by post or courier. All that is not done. Everything was transferred online. It is easy for the registry of institution like BIMAC or whichever organization. It was very easy for them to manage the case better. As I already said, the productive time was very effectively used. We didn't have to waste a lot of time. As I said, everything went in a clockwise precision. Okay, 22 minutes, 30 minutes, 40 minutes, whatever you call, yes, within that, we used to manage very well. And flexible hours. Okay, what in BIMAC we followed is that no mediation can continue beyond 1 hour at a stretch. We wanted to ensure that the parties and the lawyers do not get strained looking at the computer monitor for long hours, because we wanted to help them to relax their eyes and focus a little bit and then come back. So we used to have a break, what we called as a wellness break for 5 to 10 minutes. Even the session, you will have a wellness break of about 5 to 10 minutes between each session. Is to help the parties, the viewers sitting before a monitor, to relax a bit, wash your face and come back, because mediation can be, you all know that mediation can be absolutely strenuous, emotional, and someone needs to relax a little bit. Okay. The other advantage of online mediation is that there's no constraint for space. There may be in family disputes, especially in family partition disputes among brothers, sisters. It is not uncommon to see about 20, 30 members from a family coming into the mediation room. Okay. Even in a private session, we'll have about 10 or 15 people together. And it'll be so congested, can be humid, miserable. It's very difficult to ask everyone to go out. And so, but this online mediation helps us to have all these people from many parts of the world. You may be from Guatemala, France, or USA, or Fiji, wherever it is, they could log in. Similarly, wherever in India, they can log in. And I can accommodate any number of people on screen. So space was not a constraint at all. And I said, document sharing was it was easy. Just as we are seeing this sharing of these documents, anyone wanted to share any document could straight away scan it and share it, and the mediators can have a look at it, or it can be passed on to the other side too. The great advantage that we have is, again, private sessions, breakout rooms have become convenient places for having private sessions in online mediation. These are some of the advantages. Others would have had many more advantages, but these are my experience and experience of my friends in BIMAC and Bangalore mediation centers who have shared their thoughts with me. But coming to the concerns, we are concerned in India as to what sort of internet penetration we have. This is always a challenge. As you see, it's just 50% of our population have gone digital. Okay, we are not talking about 2021. In 2020, it was 50% of our population went digital. Digital, when I say that they have an access to a smartphone or access to a computer or a laptop or a pad. But when you say 50%, we have a population of 1.38 billion. And so it's a significant number. And the transition gets easy. But we have a long way to go. The bandwidth is always a major challenge to us. Some places we have only 2G connections. Some places there are 3G connections or 4G connections. So poor bandwidth causes interruption. This can be irritant during a mediation process. When a mediation occurs, no one likes to have a disturbance by way of dropping in internet signals. It breaks the continuity. If a party is saying something, we mediators have been trained to be active listeners, not even to interrupt when a party is saying it's his or her problem. We quietly take down the notes with the eyes fixed on the person and listen totally. It's only at the end we summarize and make a summation as to what the person said. But when there's an interruption, imagine if you are a party trying to say something which a lot of information you want to convey in a order of the continuous order. When it gets disturbed, you may lose the thought process. The line of thought is lost, and what I want to say or you want to say may get missed out. This one disadvantage we have with respect to poor bandwidth. I've already said about continuous session can be a strain. And another issue is not all of us are tech savvy. I'm not tech savvy. I may have to depend upon my children to come on, help me out with new technologies. I would have been tech savvy about 20 years ago when the computer and all came. But we, as senior citizens, they get outdated, and it's unfair for the senior citizen to expect them to log in. Imagine if an 8-year-old person who is not very familiar with computer, who needs to have the help of someone, wants to share some confidential information during the mediation process, has someone sitting next to him or her trying to, and you'll find difficult to say any confidential information. These are the small things which I have come across. Now, other issue that comes across, I've come across is that there are some cases where the parties become emotional, very, very emotional. Some parties start crying, weeping, or sometimes they tend to get angry. Now, in a physical mediation, what we do, we try to handle the emotions very effectively. There are various techniques. All of you as mediators have been trained how to handle emotions. That amount of physical interaction is definitely lacking. And that's one of the disadvantages, I say. And I also talked about concerns regarding surrounding privacy. Now, what do I mean by surrounding privacy? There are cases where I said because of digital divide, I may not have, I'm a party, I may not have the internet connection, or I may not have a laptop, or my bandwidth is low. Then I may have to go and take the help of maybe my lawyer. He'll say, come and do it in my office. But my lawyer's office, I find many people walking around here and there. There's not much of privacy. Similarly, I may go in to take the help of someone else who's willing to help me out with the presentation, with a private session with the mediator. So these are the issues on privacy, which from the localized privacy, I would rather call. The other issue that I've worried about is sometimes I fail to take notice of the body language, effective body language. Not all in a commercial mediation, it's different. But the beauty of a mediation is to observe the body language, observe the para language. Okay. And we get immersed as to how these people are. You can try to understand the attitude, the trait, the behavior, and also the trend of mediation, in what sort of mood they are, which I find not that effective so far. Maybe, I don't know, others may have a different opinion. So I said also distractions at home and office. If I'm having as a mediator, I'm working from home, I'll have my dog barking, or my neighbor right now, there's some knocking, there's some repair going on the next door. These are things which I cannot control. So these are small disadvantages, of course. Now, what is the way forward? Is the online mediation has come to stay? Are we going to totally say no to physical mediation, or will physical mediation not happen at all? Well, it's going to be something, a mixed bag. There may be some people who ask for physical mediation, but not many. And from what I understand, people are very, very happy with online mediation. I find there's a mindset of people have changed quite a bit. Lawyers also prefer online mediation because they save a lot of time. They can sit and do multitasking, as we say. Okay, well, the party, the client is talking privately with the mediator. He may step out and he may be attending to another call or attend to some other document. So lawyers do prefer. And cross-border mediation has definitely been on the rise. I've been doing quite a bit. I did some huge community mediation with respect to a European Union bank involving environmental issue. It went off so well, and we had about nearly 30 to 40 participants in those mediations. So cross-border mediations become convenient. People don't have to travel, come around to one place to mediate. So thus the cost has come down. And it's extremely cost effective. So people have tasted these advantages, and it's difficult for them to go back to physical mediation, is my humble opinion. So with this, I think I've come to the end of my presentation. I hope, Mr. Vivek, I'm well within my time, or must have overslept a little bit. And
totally fine, sir.
Thank you. Thanks a lot. And I'll try to answer some of your questions at the end of the session. Thank you, Fabienne.
Thank you, Thiru. Yes, we have already received some questions. We will handle them after the other presentations. Thank you for this very constructive preview point coming from India. And now we are going to Europe, and I will give the floor in a few seconds to Pasquale, Lino, Orrico, coming from Italy. So Lino practices as a lawyer at L'Excellent, and also is a recognized mediator at In Mediatione. Lino is a secretary of the Equal Opportunities Committee at the Milan Bar Association and a very active member of the Commission for International Relationships of the Milan Bar Association. Lino is also participating very often to the UIA World Forum of Mediation Centers and was a speaker in January 2020 in Milan, just before the pandemic. About the topic, Lino is going now to explain how online mediation is developing in Italy. The floor is yours, Lino.
Thank you very much, Fabienne. And thank you very much to all the audience, and to BEMAC, of course, for inviting me here. It's really, really honor to me. So, as Fabienne said, I will share with you a few slides. Okay. Yeah, okay, great. So, as Fabienne said, I will talk about how the pandemic impacted on mediation in Italy and how the issues were solved here in Italy. Of course, as many of you may know, we have a legislative decree that gets mediation mandatory for some dispute matters. As you can see from this slide, some dispute matters have to be preceded by a mediation attempt, and are subject matters that contain a lot of proceedings, like real estate or inheritance, or for instance, medical malpractice, banking, insurance, financial contracts. And it's a huge number of proceedings have as a prerequisite for the admissibility before a court mediation. So the mediation procedure is very easy, and the first meeting takes place, and the parties are informed by the mediator of what mediation is, how it works, and what is intended for. So after that informative session, the parties are free to decide if to go on with the mediation proceedment, or if they say no, they're free to file a lawsuit. Of course, this is very, as of course, impacts of the admissibility of claim, and there are specific skills required to lawyers. Consider that as mediation, you cannot say that is really an ADR in Italy, because it's now, as a prerequisite, it's a part of a proceeding. So also to have a lawyer is mandatory. And what was the impact of COVID on mediation? As you can see from the statistic numbers of the Ministry of Justice, on 2020, the number of mediation decreased, of course, but it not decreased that not so much. As you can see, we had 754 mediation that filed on 2020, but it's about 20% compared to 2019, where there were 147,791 mediation introduced that year. And we can also focus on the months during the pandemics. That is the second quarter that you see on the right. During the month of May, June, and July, there were 22,000 mediation. That is compared to the 32,000 mediation the first quarter. Is not that it was not a decrement, a big decrement. So we can ask how that was achieved. First of all, there is another preamble that is important, but of course, as a prerequisite of the proceeding, mediation was interpreted by the court, and we had a Supreme Court decision on 2019 that specified that the success of the mediation activity is placed in the direct contact between the parties and the professional mediator, who can, thanks to the direct and formal dialogue with them, help them to reconstruct their previous relationship. What does it mean? That, of course, to have direct contact during pandemic, of course, it was impossible. So how the government solved that problem? There was a decree on March 17th, considered that the total lockdown in Italy started on March 9th. So very quickly, the government had many laws in order to get to solve these problems. And we can see from this decree that in the period from 9th March to 30th June 2020, mediation meetings can in any case be held online with a prior consent of all the parties involved in the procedure. What does it mean? It means that the government admitted the online procedure also for mediation that are prerequisite for before starting a proceeding before a court. But that was very important. Also, another thing that even after this period, as the decree says, the meetings may be held online with the prior consent of all the parties involved in the procedure. So it was, we could say that it was an opportunity to have a progress in and a very important implementation in the proceeding of mediation in Italy. And it is very good because also nowadays that direct meetings and meetings can be held in presence, online mediation is still used a lot. So, but how does it work, online mediation? Of course, as a prerequisite of a proceeding, and also having effects in case of an agreement, because a mediation agreement can be enforced in Italy. Remote mediation has a very strict procedure. So after the meeting, that it can be held online, of course, by video conferencing. And I know that Fabienne will talk about privacy in that meetings, and that's very important issue. So sorry, there is a mistake. The mediator drafts minutes. After that, the parties sign the minutes and email it to the lawyers. Of course, every kind of transmission of a file is admitted. So the clients used to have sometimes to get a peek of the minute, sign it, print it, sign it, and send it via email or via WhatsApp, for instance, that very used here in Italy. After that, the lawyers digitally sign the minutes, and in that way, they also certify the authenticity of their client's signature. Of course, maybe you can have an objection. Not all lawyers are supposed to have digital sign. That's not true, because also the civil process nowadays, also criminal law process and processes before the Supreme Court are completely digital. So we used to file documents digitally signed, and for that, of course, a lawyer is supposed, and it is mandatory, it's not supposed, it is mandatory that a lawyer has both a digital sign system and a certified email. So after that, the lawyers digitally signed the minutes. The mediator that digitally signs the minutes, and that is an official document in this, of course, digital original that can be transmitted by email between the parties and the lawyers. But what if the parties get an agreement? As I said, of course, mediation agreement can be enforced, just like a court decision. I have to say, of course, that it's an exception that mediation agreement has to be enforced, of course, because I think that it's in the spirit of mediation, and the result of mediation is divide an agreement that be spontaneously get into effect by the parties, because, of course, all the parties agreed that agreement. So, in case of agreement, the mediator again digitally signs the agreement that has been signed by the parties and the lawyers, and it is transmitted by certified email. This request for notification can be filed to the bailiff by certified mail. And after that, of course, the bailiff has to deliver it to the party, and it simply prints it and certifies the authenticity of the digital signature of the mediators and of the lawyers. So after that, the agreement can be enforced very easily. And I also have to say that the same procedure is provided for the decisions. Also in these cases, the decision can be transmitted via certified email to the bailiff, and then he delivers it in paper, of course, with the delivery of an analog copy to the party. And it was really a success, because as you could see from the statistics, the impact of COVID, thanks to digital procedure, was really low compared to many other branches of the economics. And it was so successful that nowadays the Minister of Justice, that is Ms. Marta Cartabia, published some guidelines for the future of the laws of regarding the proceedings, and she declared that mediation must be affected by amendments that aim to extend its mandatory application, namely in those subject matters where it was more successful, because we also have voluntary mediation. It's very successful in many other branches. I can say, for instance, in dispute between workers, or also because of the relationship between, for instance, of economic problems because of COVID. There will be also further economic and fiscal incentives that we already have, but they will be increased. And also the power of the judge to delegate the mediation during a process. So Thank you very much. And after that, there will be time for some questions, of course. Thank you very much again.
Thanks, Pasquale, Lino. And the last slide was an important one. We saw trust in online mediation. And so, yes, everything is a question of trust. You're right. Thanks a lot for those information. So now I would propose to stay in Europe and to go to another country. We're going to go to Belgium and meet with Gérard Kuyper. Gérard is a lawyer at the Brussels bar since 1992 and is practicing law in commercial law, civil law, but is also an accredited mediator since 2008. And not the least, because he's also the president of B Mediation in Belgium and the co-founder of Alteris Law and Mediation, with the very first law firm, Belgian law firm, where all partners are accredited mediators. So Gérard is also participating often as a speaker to the UIA World Forum of Mediation Centers, and we are very honored to have him on board here to share his thoughts with you in India. He's a passionate of communication techniques and the use of them in conflict resolution. So now, Gérard, we are looking forward to listening to you now.
Thank you very much, Fabienne, and thank you, Thiru and Biomac, for the wonderful organization of this webinar about a very interesting subject, topic about mediation. We are always, and all of us, involved in mediation. I'm sure I'm talking with people that are very interested in mediation. So I will share with you some information and some ideas about mediation in Belgium with a first, so if you see correctly so my slide, I will share with you some ideas about online mediation in the framework of online dispute resolution, first step. Afterward, I will give you some information about the market of online mediation. What are we talking about online mediation, ODR, and so on. Some ideas about online mediation, different ideas in comparison with everything has been already said by Thiru and by Lino, and some ideas about online mediation in Belgium to close my presentation, if you don't mind. First of all, what are we talking about online dispute resolution? I think that online mediation is part of the more general called online dispute resolution, and you can see two branches, in fact. A first branch focused on communication tools with email, internet forums, communication video, etc. So it's focused on people, in fact. So the question asked is who, and this first branch can be divided in two branches about alternative dispute resolution, but also a judicial dispute resolution. So I'm talking about court using online tools in order to settle the dispute. And that's a first point in my point of view. And so if you can see my, I don't know if you can, I will use something to show. So what we are calling online mediation, it's a part. I call it digital of online mediation. So it's a part of the more general online dispute resolution system. On the other end, so the other branch, we can talk about decision-making tools. So artificial intelligence. And the same two branches you see about communication tools, you can find them in about the decision-making tools. So ADR, GDR, and about decision-making tools, you are talking about tools for analyzing the case file, the dispute, tools about the organization of the negotiation, the evaluation of the proposal made by the parties. So you know that by now, artificial intelligence can be used to evaluate the proposal, the cases, and to have a hand of a support to the negotiator, but also to the judge in order to settle the case with particular problem, in my point of view, a concern about the anchoring bias. You know, we are talking about cognitive bias. One of the bias is the anchoring bias. So if you have a main information saying, okay, in such cases, the more common solution is that way to solve that solution. It creates, in fact, an anchoring bias, because you will compare all the other solution or all the other way to solve the problem with the more common way defined by an artificial intelligence. So it can be a major concern, but we have not enough time to manage this very interesting question about the influence of artificial intelligence on our way to solve. But in the ODR, this question should be very important in the future. And so decision-making tools are related to the question of what are we talking about, and the question of content. So these 2 points have to be considered when we are talking about ODR. About the situation, and I am speaking about the situation in Belgium, but not only in Belgium, and in the European market. The question of using the ODR, online dispute resolution, can be found mainly in B2C, business to consumer litigation. And you have on the market a lot of legal tech managing claims from marketplaces like eBay, like Amazon, PayPal, etc., etc. And such cases are have particular features. First of them is the low stake of the dispute. More or less, we are talking about €100, $100. It's the same. So it's small cases by and large. You have a lot of cases, a lot of claims. We are more talking about claims, in fact, coming from customers, consumers that are not happy with what they have ordered, and mainly what they have received and collected from the providers. So there are so many about. I think about eBay, we are talking about 1 million of claims. You understand that no state, no judicial state structure can be able to handle so many claims, in fact. So that's why private systems, legal tech, are used to propose an answer and a solution in the framework of an ODR system to manage all the claims coming from client. In such litigation, we can observe that the solution proposed to people are very are in a limited range, in fact. So we refund the money paid, or we can propose an exchange of the goods, and maybe other solution. But the solution are, you have 1, 2, or 3 solutions, but not more. And it's done because it's done like that because with legal tech and artificial intelligence, it's easier to manage a lot of claims related to such problems with a limited choice of solution. If you have a lot of choice of solution, the managing of such system will be harder. When you manage such litigation, you can see that, and that's provided by the regulation, European regulation, but also the intern regulation from the legal tech. The speed to resolve the case is very, very high. People have a maximum 30 days to find an amicable solution. Otherwise, the system will propose a solution and will fix the problem by imposing a solution with a compensation or a punishment against the provider. It's the question of the reputation. I will end this slide by this question. In fact, such system is more conciliation and arbitration than a real mediation, if real is a correct term with online mediation. But I mean that with mediation, I think that people have to understand themselves, and and each people has to understand the other. Or but in B2C litigation, there is less question to understand the other people than finding a quick solution to a problem. So the question is more what than who in such a problem. And that's why I prefer to use the term conciliation than mediation. And the legal text, if you can accept such idea, can be considered as a low-cost tool for dispute resolution. Such legal texts are regulated by a EU regulation number 524 from 2013, related to B2C disputes, so business to consumer. And the regulation provides duties, obligation to the provider. So each provider has to propose free of charge way of amicable settlement is mandatory, and such way to find a settlement must be submitted to regulation that seem equal to the judicial procedure. So fairness, neutrality, independence, and so. So that's a particular way to solve dispute by online resolution systems. The best tool for the B2C litigation for small cases seems to be the online conciliation, and it focuses on the content, not on the people, and I can give you as image or illustration of my speech is the situation of eBay, and it's the same with Amazon. eBay has a system, an electronic system focused on solving problems. It's a dispute resolution system with someone after beyond the screen, and it organizes a relation between the claimant, the disputant, and the provider. And parties have 30 days, maximum 30 days to find a solution. And after that, the regulator, the organizer may decide who is right, who is in default of its obligation. And linked to the PayPal system, the organizer can enforce by its own the solution by a refund to the consumer or a penalty imposed to the provider. And the problem is for the provider, but also for the client, is that because you are ranked on internet, you have stars, by instance, for on Google, or you have a quote from eBay given by your client or provider. The question, and it's very important on the website, the question of the e-reputation is very important. It's a powerful enforcement tool, in fact, because as you know, when you are making a search on internet, 90% of the time you are closing your research after the first page of Google. So the e-reputation is very, very powerful to enforce the decision, arbitration decision, coming from the marketplace litigation dispute regulation system. So let's talk quickly about online mediation. The question is, we know that we have online mediation system for consumer. Okay, it works, but how can it work with more complicated, more complex conflict? And let's think about the way we think when we have a conflict, a dispute. Please remind that first of all, we are creating a story. We are building a story coming from the facts and our perception of the facts. And by the way of an inductance, say induction in French, we are creating the story. We are creating a new reality, in fact. And our story may be translated into law. That's the question and the role of the lawyers. And based on the story, the story is improved by our feeling, or knowledge, or experience, or past, etc., etc. And so, based on the facts, based on experience, we are convinced that what we know is the reality. And the problem is that the other party, the other disputant, has another reality. And so we are building a story. We are taking our decision based on this story, and next we are taking an action. And that's the beginning of the, I call it the vicious circle of conflict, and you see on the other slide, think at the first disputant. He consider the facts, is considering the facts, building its story, making a deduction and finding a solution. He make his choice between several actions. He take actions. The action constitutes one of the new facts considered by disputant 2. That makes the same way of understanding and creating its own reality, its own framework of dispute. And it will also take a decision and an action. And this action is the first step for the new reality of disputant 1. That's the problem of the vicious circle of misunderstanding, and that's a source of all of our disputes. And the problem is to know how we can manage such circle with online mediation. Findings coming from online meetings. Let's coming from other, not only mediation, but meetings by and large. Online meetings are very easy to organize. Thiru has give us a lot of information on that point. Sorry, I'm urging. Thank you, Fabienne. I'm too long. Sorry. So you have advantages. I'm connecting to what Thiru has said about advantages and disadvantages. Sorry. So let's see in mediation. I think it's my point of view, and I will close my speech on this. We can make a mix between online tools and meeting with the presence of parties, and everything concerning the question what can be managed easily online. But the question of who and the question of relationship between people must be mainly managed by with the presence of people. And so the caucus can be managed online. The draft agreement can be managed online, and it was already presented by Lino. So we can make, and that's my message, we can make a mix between all the system. In Belgium, and I close my speech with that point, we are, the Federal Commission of Mediation was promoting the online mediation, but in fact, there are less online mediation, mainly conciliation and about commercial activities. But the government had decided to create a moratorium on bankruptcy. So we were closing a lot of dispute. In fact, creating a moratorium of the dispute in order to avoid a lot of dispute. Sorry to have been so long, and all my apologies. I wish you a pleasant end of the webinar, and I'm of course at your disposal to answer the question if ever.
Thank you a lot, Gérard, for those thoughts that you shared with us. Now, and before coming to the questions, we will stay in Europe, and I will share with you some thoughts myself. I think that you may see my slides here. Let me just put it here and jump it here, there. See here. Yeah. Oh, sorry, I made a mistake here. Yes. So I put again my slide in front of you. So some technical problems. I have to open it. So
Your slides disappeared. I think you need to
Yes.
share it again.
So here, yes, sorry for that. Technical problem, so I guess you see it now.
Yeah, and you need to enlarge them, that's it.
I need to, enlarge them. Sorry to make it here, yes. So do you see them?
BC, yeah, it's okay.
Yeah, yes. And this is, okay, some words now that we may share together here with some thoughts coming also from France. Is it okay for you? Do you see my slides correctly? Yes?
Yeah. Yes,
okay.
yes, we can.
Good. Thank you very much for your understanding for those technical problems. And this is in fact done on purpose because we speak about technically also online mediation. Online mediation confidentiality, is this an issue? Is this really an issue? Here, as president of the World Forum of Mediation Centers, we organize this forum every 9 months. And this UIA forum that I have the pleasure also to preside has already spoken about these ODR problems some years ago already. In 2013, we discussed online mediation when we were in Czech Republic, and we had a session about online mediation. In 2017, we also discussed during our forum in Singapore the problem of ODR, and we discussed ODR platform, which was designed especially for dispute resolution. It was Modrum, and a person came to present this online dispute platform. And later on, it's September 2020. Well, during the pandemic, we organized the forum and we invited again the founder of a platform especially designed for online mediation, which was Modrum. This is just to let you know that online mediation is something that does exist already. It will continue to develop, this is certain, because of COVID, but also because it is a necessity for people and also a very useful tool. And I would like to share with you some thoughts that I had about that. Let's speak very straightforwardly now. Mediation is above all a process of the parties. The trust is important. Parties trust the process and parties trust the mediator. And if the mediator is mastering the technology online, he will bring himself or herself the confidence in the process online. Previously, that just here in the beginning of my presentation, when we have technical problems, we may lose confidence. But if we master the online process, we bring confidence in the process. So when people speak online, they also speak very frankly. Is this an issue to speak online? When you see a movie, you may cry, you may feel great or sad. Feelings are also transmitting through online. They are also created and they are possible online. So in my viewpoints, feelings are also possible during online mediation. So myself, I really truly believe that online mediation is just impossible to avoid. It has existed and it will exist again, and it will be developing in the next generations. When COVID and a pandemic appeared, some mediations have been completely suspended. Some have been cancelled, but some have continued online. And others have been organized and initiated directly online. See, I think that technical tools are being developed, they are used, and we may and we must trust the technology to make sure confidentiality of the process is ensured. Is confidentiality an issue during online mediation? In my viewpoint, no, if the technical tools are trustworthy. And can a mediator work with efficiency during an online mediation? In my viewpoint, yes, because parties will continue to trust the mediator because he's mastering the process and we have trust in his authority. So in mediation, as I said when a little bit previously Lino finalized his presentation, in mediation process, all is a question of trust. Trust may be built with online mediation, and online mediation is a part of our future. We may like it, we may dislike it, it is a fact. And this is my viewpoint. So thank you also for sharing those thoughts with me. And of course, we are here ready to speak about again and continuously about online mediation. We still have some time and we have also questions coming. Perhaps we may share with them here with you because those questions are coming from the audience itself. I have here in front of me a question that is directed to you, Thiru. Perhaps if you accept to listen. Sir Thiru, to progress online mediation, parties and their advocates have to choose the same. What is the best way to bring awareness about online mediation amongst them, that is, parties and their advocates? Did you hear the question, Thiru?
Yeah, I heard the question. Thank you, Fabienne, for enlightening us on the importance of confidentiality and trust. Was very, very, it was basically a very important point you touched in online. Yeah, regarding this particular question where how do you create awareness? The awareness is from the support we should get is not just from centers like BIMAC, but we need to have the support of the largest profession in country like India. It's the bar. The bar and should help us to promote mediation, especially online mediation. And I'd rather call it as bar gaining. It's not bar losing. Bar would stand to gain if they help to resolve the client's dispute very early through mediation. More and more clients will approach the lawyers. That is my experience too. In addition to it, yes, we need to take the support of organizations like the establishment like the courts and government support. And then there are organizations like the Rotary, Lions Club, the Roundtable, and so many other NGOs, non-government organizations. They should also lend a supporting hand. And because the theme of this conference is social justice through mediation. So we can achieve social justice when the society itself supports, realizes where we stand, and that justice should reach the common man. So we're going to be a collective effort. Thank you.
Thank you. I also have a question that was raised by the audience a little bit earlier that said, is it important also to give information to the parties and the lawyers in order to make sure that online mediation is well organized? That is, for example, to inform them and to remind them that, of course, if you participate online, please be seated in a room that is adapted to the circumstances. Please do not be on your bed to speak, sometimes. Please make sure that, everything is okay behind you. Do you make specific information to the parties and to the lawyer because of online mediation? Perhaps an experience coming from Gérard or Lino?
May I answer?
Yeah, go ahead, Lino.
Yes, of course. The lawyers of the parties and the mediator, of course, have to declare before the session starts that they're alone in the room. And I'm also saw another question about confidentiality, because someone asked if, for instance, the minutes can be filed before the court. The answer is no, because confidentiality of the mediation process is granted by the law. That means that all the minutes, everything is declared, everything is written during a mediation process is to be considered confidential. After a mediation process, if parties don't get into an agreement, then the only thing that will be filed, the only document will be filed before a court will be a certification on the mediation center declares the parties tried to get to mediate but didn't succeed. And of course, if an agreement is reached, that will be public and enforceable. But in all the other cases, everything is said or written during a mediation process is confidential.
Okay, well, and also when you spoke, Lino, you said that the document has to be signed by the mediator at the end, which is not the case in all the countries. Do you confirm that mediators must sign the agreement coming from the mediation process? Is that well what you said previously?
Sometimes I had some mediation with not Italian parties. And as I said, the Italian lawyers can get declared as authentical. The signature of the client can be emailed. So the client, and that is the party in the mediation, don't have necessarily, does not need a digital signature. It's enough a pen, and then after that, it's the file, the document scanned, signed, and sent to the lawyer that certificates the authenticity of the signature of his client.
Good.
And another thing that I say, someone asked about where is the original of the agreement if it is digital. Consider that it is a file, and that means it is the bit stream of the file is exactly the same as another file. They have the same bit stream. They are both original, because it's not a piece of paper that can be only one, of course, but files can be reproduced. Of course, there are some softwares that can verify if a file is original and authentic. For instance, hash codes or other things.
We have noted that in Italy, legislator has intervened when pandemic came because they had to change the text. You said no need of direct contact because, of course, it was impossible. May I ask if Belgium has reacted and if Belgian courts order some online mediation when pandemic occurred?
In fact, Belgium courts haven't ordered online mediation. They, during the first period, Belgian courts prefer to use written procedure, in fact, to manage the cases. And when the court reopened physically, the hearings worked as it was managed before, with masked frame and so on. But what happened since the new law, the new Belgian law, that gives to the judge the opportunity to enforce people to go into and to enter into mediation. The fact is that the judge push more and more people to go for mediation. And it's not directly linked to the pandemic, but it's one of the consequences in relation with the crisis we had to live with companies losing their market and so on. And judges are convinced that the Belgium law, it's not fit with the situation, and judge ask the people, ask parties, disputant, to try to solve the disputes by a negotiation or by a mediation. But it's not a question of online mediation. And Belgium is a small country. Look, it's easy for each people to have a meeting. But clearly, judges are pushing people to try to negotiate and to find their dispute by themselves. That's very, very clear, actually.
Okay, well, this will be the conclusion of this session, the fact that the judges are very open to this modernity, and the fact that our new generation of mediators will be using more than probably online mediation. And I really hope that the thoughts that have been shared during this session have given ideas to the mediators who have listened to us. And I really would like to thank Thiro to have given this opportunity to share all those thoughts together in this wonderful program. So I guess now it is time. I thank you a lot, Pasquale, Lino, Gérard, Kuyper, Thiro, and Vivek for this wonderful organization. And I guess I may give you the floor, Vivek, for the continuation of the sessions.
Pleasure.
Thank you, Fabienne. Thanks a lot. You've been wonderful, and all my co-panelists, you have been wonderful, and such an information that you shared. Over to you, Mr.
Thank you. It was a really deepening, enlightening to hear the futuristic out-of-box approach from the wonderful moderator and the speakers today, and the patience and endeavors of the attendees to learn something new today. The questions were relevant. I'm really very happy that participants were active in asking questions, and there had been a lot of questions on the board as well. So on behalf of BIMEC, I convey my great thanks and gratitude to the moderator, the speakers, and attendees for having made this session successful and fruitful. Before I close this session, I request to all the attendees to please stay connected, as we shall be joining back after 5 minutes wellness break for the next session. Shah and Namaste.
Good morning. Good afternoon.
Good morning, Andrew.
How are you?
Very well, thank you.
Hi, everyone. This is Meng.
Good morning, good afternoon, good
Hi,
evening.
Andrew.
How are you?
I'm good.
Nice to see you.
Good evening, Mr.
Likewise.
Lomesh, and good evening, Mr. Miller. Good evening, Mr. Meng. Good evening, Justice Dinesh Kumar, who I think has also joined us. We will start session 2 shortly, also waiting for Miss Anna. And I think we should start exactly at 5:30. We just ended session 1. I hope all of you are able to see me and hear me.
Loud and clear.
Perfect.
Yes, we can. Yeah.
I assume the questions have not changed.
We'll find out.
We'll improvise. How many are we expecting?
We have around 400 plus people who registered, and there are currently 137 participants.
Oh, I can see at the bottom. Yeah, thank you.
And this is also being live streamed on YouTube, so people are watching from there as well. I see Justice Dinesh Kumar has joined us. Welcome, sir. It's our honor to have you.
Good evening, sir.
Good evening, Justice.
Good evening, you judge.
We're still waiting for Miss Anna. It's 5 a.m. in California, and she's going to join us from there. So I think she should join us shortly. It's 5:30 right now. I'd just also like to welcome one of my colleagues, Miss Siri Prasad, who's also part of Team BIMAC. And I think we're good to begin because it's 5:30. Right. So welcome everybody to session 2 in day 2 of our International Mediation Conference. We just completed session 1 on online mediation during the pandemic. And this brings us to this session, which is, should there be an inclusion of cross-border family business disputes and cross-border e-commerce, B2C or business-to-consumer disputes within the scope of the Singapore Convention? Our moderator for this evening is Honorable Mr. Justice P.S. Dinesh Kumar, Judge of the High Court of Karnataka. Honorable Mr. Justice P.S. Dinesh Kumar was admitted to the bar in the year 1990 and worked in the chambers of Honorable Mr. Justice Shivraj V. Patel, former Judge, Supreme Court of India. In the year 1998, he functioned as an additional central government standing counsel. In 2003, he became a senior standing counsel for the Government of India. He has served as senior panel counsel for the Central Bureau of Investigation, CBI, the Union Public Service Commission, University Grants Commission, All India Council for Technical Education, National Council for Teacher Education, and several other organizations. He has appeared in several important cases in different high courts and Supreme Courts in matters concerning appointments of directors, CBI, disinvestment of ITDC hotels, defamation cases against the Union Finance Minister, corruption cases against former Union Minister and former Chief Minister, and he's also worked with eminent law officers of the country. Before his elevation in January 2015 as a judge of the Karnataka High Court, he rendered pro bono service as a mediator at the Bangalore Mediation Center and was also a trainer in mediation. As a sitting judge of the High Court, he's been a great supporter of mediation at both the Bangalore Mediation Center as well as at BIMAC. Thank you, sir. It's an honor to have you here. I'll just quickly also introduce the other speakers that we have from across the world before we start this session. We also have Mr. Chuan Meng. Mr. Meng is an experienced general counsel of 30 years working in Beijing, Hong Kong, and Singapore. Prior to joining SIMC, he served as a general counsel of IBM, Greater China, and Nortel Networks, Asia Pacific for about 20 years. He has advised senior leadership of MN as lead counsel on legal and regulatory issues arising out of doing business in China, Hong Kong, Taiwan, India, Japan, Korea, Asia, Australia, and New Zealand. He's an active board member of the US-China JVs and has managed a wide range of emerging market risks with leading international best practices. He believes the high-risk, high-potential Asia-Pacific markets require a robust management practice that balances creativity with integrity to ensure sustainable business growth. Leveraging his deep regional experience, he is currently leading SIMC to promote mediation to resolve complex commercial cross-border disputes in the Asia-Pacific region. Mr. Meng is an accredited mediator of the Singapore International Mediation Institution. He graduated with a law degree from the National University of Singapore and holds a Master's of Law from the University of Hong Kong. He is also called to both the Singapore Bar and the Hong Kong Bar.
Thank you.
With us this evening, we also have Mr. Andrew Miller, who's a Queen's Counsel. He's a barrister with over 30 years of experience in dealing with and resolving commercial disputes, both domestically and internationally. He now practices as a mediator and arbitrator in a wide range of commercial sectors, including the areas of construction and energy, as well as professional negligence. Mr. Andrew is the current NMA Civil and Commercial Mediator of the Year 2020-2021, awarded in September 2020. He's been involved in mediation disputes since 1995 and has experience of over 200 mediations across a wide range of disputes and has acted as a lead mediator in commercial disputes valued from £50,000 to £50 million. He's also mediated disputes with parties across the world from the UK, Australia, Canada, France, Germany, Hong Kong, Italy, and several other countries. He regularly speaks about mediation in the UK and internationally, and he has also been involved in a series of workshops and seminars in India. In January 2020, he was invited to speak at the Supreme Court of India on mediation and its relationship with litigation. He also sits as an arbitrator and has been a trustee of the Chartered Institute of Arbitrators since 2019. Thank you for being with us here today, sir.
Pleasure, thank you.
Thank you, sir. We have with us Mr. Lomesh Kiran Nidumuri. Mr. Lomesh has a wide experience advising and representing clients in arbitrations, both domestic and international, and complex commercial disputes. He acts as a lead counsel in several disputes before arbitral tribunals as well as courts. He obtained his master's in law from the New York University School of Law with a focus on international arbitration and dispute resolution. He's been selected to be a mediator of the SIAC Reserve Panel of Arbitrators and has also been appointed to the Committee of Young Singapore International Arbitration Center, SIAC, for the term 2019 to 20, as well as 2021 to 2022. He's one of the conveners of the India Arbitration Forum, IAF, and he's been recognized by for dispute resolution by the Chambers and Partners Global and Asia Pacific Guides. He's been recognized by the Legal 500 Asia Pacific, by Asia Law Profiles, and Benchmark Litigation 2020 and 2021 features him as a dispute star in the categories of international arbitration. He's a partner of Indus Law, a reputed law firm, and he's from Bangalore. Welcome, sir.
Thank you so much, Ramya, for having me here. Thank you. My pleasure.
Thank you, sir. And I see that Ms. Anna has joined us. I understand that it's very early for you, so our deep appreciations for you for joining us at 5 a.m. your time. Ms. Anna is an internationally recognized mediator, attorney, and leader in the field of conflict resolution. She's the principal and founder of Sombold Law and ADR, a California firm dedicated to providing mediation, arbitration, and dispute resolution services. Ms. Sombold has served as a neutral in over 1,000 cases across a broad spectrum of civil litigation matters. She's a diplomat member of the National Academy of Distinguished Neutrals, an international mediation institution, IMI, certified mediator, and is on the International Council for Online Dispute Resolution, as well as the International Arbitral Tribunal. She has taught extensively in conflict resolution, ADR, negotiation, and the Singapore Convention on Mediation. She was invited by the Singapore government to the historical signing ceremony, and she's also a prominent leader in legal and ADR field and actively advocates and advances mediation and ADR through her different leadership roles. She's an executive officer of the American Bar Association, ABA, section of dispute resolution, and the co-chair of the ABA Advanced Mediation and Advocacy Skills Institute. And she's the chair of the San Diego County Bar Association ADR section, as well as the president of the San Diego Law Library Foundation. Thank you so much for being with us today. And I hope everyone enjoys this session. I'm sure it'll be very insightful. I now pass on the mic to Honorable Justice Dinesh Kumar, who's the moderator of this session. Thank you. So you're on mute. If you could unmute, that would be great. It should be a button at the bottom left corner. So we're unable to hear you.
Perhaps the organizer can help him to unmute.
Yes, I think there was an issue with connecting to audio, so I'll just recheck. Yes. Kindly bear with us for these technical difficulties.
He may have to sign out and come back in.
I was just about to get on a call with Justice Dinesh Kumar to assist him, but thank you, sir.
The joys of this technology.
Well, the fact that we could be calling in from all over the world is just amazing.
I know. And it's 5 in the morning here in California.
Stop
That's
boasting, Anna.
amazing. I know.
It's 8 p.m. in Singapore.
Evening, am I audible?
Yes, you are, sir.
Yes, sir. It's totally audible now.
Right.
You're on, sir.
Sorry for the mess. There was some problem with the computer, as always, sometimes. All right.
We can't see you, sir.
You can't see me.
Oh, we can now. Yes, I'm sorry.
Yeah,
yes.
we can see you.
We're at a different screen now. Yes.
Right.
Yeah, there you go.
Yeah.
I will close one to do this. Yes, now I think you can. Welcome, everybody here. A wonderful topic for discussion, whether the cross-border family business dispute and cross-border e-commerce business to consumer dispute to be included in the scope of Singapore conventions. We have, as I understand, 3 sessions, 3 subdivided sessions in this. Now, it starts with Mr. V. Meng. So, Mr. Meng, can you briefly tell all of us about the benefit of all our audience here, the evolution of the Singapore Convention, please?
Thank you, sir. A great pleasure to be here and to be among such esteemed panelists. So first of all, let me thank BMAC for the invitation, and what a joy it is to be able to spend this Saturday evening time for me here in Singapore to be part of this panel. And thank you, Judge, for being the one who will be helping us all along in this discussion.
Really, I must say that I'll be learning.
Thank you for moderating.
Right.
So, history is not my forte, let me just first of all say.
Right.
But I think it's important for us to understand some of the context of the Singapore Convention, because there is actually a little bit of history to it. So let me first of all start by saying that the whole idea of Singapore Convention and how it came about was really the UNCITRAL under United Nations, being able to put together different parties to help us to come to the Singapore Convention today. So UNCITRAL really deserves the highest accolade for doing what they have done. Now, the history of Singapore Convention actually goes back 20 years. 2002. So 20 years ago, I think some of the participants here may not even, maybe they may be in high school or something, but that's a long time ago. So year 2002 was when UNCITRAL decided to work on a model law on international commercial conciliation. Model law on international commercial conciliation. And I know that amongst our European colleagues, etc., the concept of conciliation and mediation and reconciliation, etc., might be a little different, but I'm going to use them interchangeably. So the question was, how do you have commercial conciliation being enforced across countries? So that was an important question for states to answer. So after some discussions, a lot of inputs from the different countries, some of the considerations were, should settlement agreements be enforced like awards? All of us are very familiar with the New York Convention. Should be enforced in the same way as an arbitration award? Is there a need for an international mechanism for enforcement? So those are some of the questions being discussed and really examined by the different countries. What eventually they landed up with is what is called the Article 14 of the Model Law, the Model Law International Commercial Conciliation, where it says that settlement of agreements would be binding and enforceable, but it's left to enacting states to insert provisions providing for the enforceability of such agreements. Meaning, at the end of the day, they leave it to the countries, right? There's no international platform to do so. Then I fast forward 12 years to 2014. In 2014, the US, so thanks to the colleagues of Miss Anna Sombold there, US then started this idea to say, they mooted to UNCITRAL to propose a multilateral convention to enforce cross-border mediated settlement agreements. So in 2014, they got started. In 2015, very quickly, the Working Group 2 of UNCITRAL was set up. And this was a fantastic group of people from all over the world. I think over 50 countries participated actively. They met at various sessions within UNCITRAL itself. New York was one of the places, and so at the end of that many sessions that they had, that was when the Singapore Convention was born. Right? Singapore took a fairly active role, I would say a very active role, because the chairperson of the Working Group 2 was a Singaporean, and we were able to help many countries to come to an agreement that at the end of the day, we should have a convention that will help enforcement across different countries. This version of the Working Group 2 proposal was adopted by the United Nations General Assembly in December of 2018. So not too long ago. And then on the 7th of August 2019, and I think that was the celebration that Anna and others may have come and joined us here in Singapore, we signed the convention, and it was a marvelous celebration of different countries coming together. There's this, I should have shared this photograph of this beautiful photograph of all the different countries in their national attire, being on stage, all of them representing their different countries. Some of them are heads of states, etc., where they sign off on the convention. Today, right, 2021, you think about it, it's just been a short 2 years, less than 2 years since the signing of the convention. We have 54 countries that have been signed on the convention, 54. And that's really one of the most successful conventions under the United Nations, and 6 countries have ratified. The countries include the USA, include China, include India, of course, includes South Korea, and I've mentioned all these are the great economic powers of the world. And the latest addition was just maybe a week or two ago was Brazil. So excellent coordination, collaboration by the different countries to come up with the Singapore Convention. Thank you.
Right, great. If I may have a question there, insofar as so many countries have joined hands, so how it has precisely benefited an agreement, mediation agreement having been arrived at between two parties? What are some salient features? Can you just quickly explain?
Okay, so some salient features would be the fact that if you have a mediated agreement, and it's defined mediation very broadly, meaning you get a third party to help with the negotiation, but the mediator must not have the ability to enforce a judgment or an award on the parties. Correct. If you have parties freely coming together to come up with a mediated agreement, that agreement is enforceable in the countries that have signed and ratified the agreement. So in Singapore, for example, I guess it's best to use Singapore as an example. It has a mediated agreement with, let's say, a party from India. That mediated agreement, of course, there are certain conditions that will apply, would then be allowed to be registered with the High Court and then enforced as if it is a court order.
Like
and
a
that gives the
decree
parties,
of the court.
As if it is a court order. So as an in-house counsel from IBM, in my former role, it gives parties, business parties, multinational corporations, a lot of confidence when they do business in Singapore, because they know that there is an option of going to court, there's an option of going to arbitration, and there's also an option of mediation as a way of resolving that the disputes. And once they have that mediated agreement, they can enforce it in Singapore under the Singapore Convention. They can enforce an arbitration award under the New York Convention. And of course, for a court order, they can enforce it. So it gives confidence to parties to do the business.
Thank you very much, Mr. P. Meng. Now we'll move on and request Mr. Andrew Maliris to explain to us as to why this United Kingdom and European Union countries are yet to sign.
Well, good evening, everyone. And if I can echo what was just said in terms of it's a pleasure to be here. And thank you very much for moderating this. It's wonderful to be taking part. Well, you're asking me as a single, whether I'm a lawyer, an arbitrator, or a mediator, as to why the huge apparatus of the UK government has not signed up. Just as an aside, where I was lucky enough in 2018 to speak at the Singapore Mediation Centre, and I was asked then if I could do anything to make my government sign. Alas, I don't feel I have that that huge power to do it, or at least I haven't been able to achieve it. So I think the reality is it's very difficult to point to a specific reason, save perhaps if we start with the first thing, and that is this sort of thing does not move fast in the UK. Other countries have managed, including, it's interesting that the US has managed to move so fast on this, but the UK hasn't. And to give an example, if one looks at the New York Convention, no one would ever attempt to sit on this panel or any panel and argue anything but than that the New York Convention is a necessity. How important it's been, how revolutionary in a sense it has been, and how it has obviously ensured enforcement of arbitration awards around the world. But having said that, the New York Convention came into force in June of 1959. And the UK government did not ratify it until September 1975. So perhaps that gives you a little bit of an idea as to how long these sort of things can take. I'm hoping that it won't take that much time going forward 15 plus years. Hopefully it won't. I think we live in a different world. So what do I think it is? Well, I think there's actually two things. And I think one of them is actually the question of enforcement itself. I think we are quite fortunate in the UK, in our jurisdiction, that the one thing with mediation, or the one thing that has not really been a problem with mediation agreements, has actually been enforcement. Mediation is taken up a great deal in the UK, but still by no means as much as it is in the US. And what that means is when parties actually decide to mediate, generally speaking, and almost, I'd say almost exclusively speaking, if they manage to achieve a settlement, that settlement is put into place. And we do not have the litigation that I know does exist in the States of parties who fall out after the settlement. Parties are generally, whether you're talking a small case, a medium, large, or even cross-border case, are glad to have reached the settlement, and therefore it generally falls in the settlement is honoured. I think that's part of it. It's not seen as being the real issue. The issue is the use of mediation rather than whether it's enforced. And I think that's, the more it's used for cross-border, perhaps the more that difficulties are seen, then there may be more of a willing to be taken up. But I actually think there's a wider consideration in the UK. And if you've asked me why it hasn't been ratified, and the question, that's why the government hasn't ratified it. And I think that's to do with the attitude of the government towards the mediation of disputes. And in the UK, it's certainly not negative, but I would not ever describe it as overtly positive. It's not a major consideration. And one of the things that we have seen, and it actually came on the back of the Singapore Convention, it is that the Singapore Convention, as I understand, was more or less done and dusted by the end of 2016. And that was when Brexit came into play. And there were key leading mediators who were involved in the process from the UK. And they actually approached relevant individuals at that time in 16, who were now then dealing with Brexit, to say, why don't you use mediators to assist with the Brexit process? And what happened was the government or relevant civil servants, I can't point to anyone individual, a lot of these are the stories that have been passed on, effectively said no. And they did not want mediators to be involved. And why? Because ministers could do it. But why would you need mediators? So I think that there's this attitude of not really understanding what the true benefit of mediation is. And I think that comes down to how much respect there is for the mediation process. And that's not just, it's not just in terms of the government, it's in terms throughout the UK. How is mediation viewed? How is it respected? And part of that issue, I have to say, is what the mediation profession does itself. Because it talks amongst itself an awful lot. It talks up mediation amongst itself an awful lot, but it needs to do more to sell itself, not simply to government, but it needs to do more to sell itself to business itself. Because change doesn't actually come in terms of, all my time, I've been a barrister over 30 years, change doesn't come from lawyers. Change actually comes from those who instruct us. They tell us to change. And we have really seen that in the last year and a half with the pandemic, because what has happened is business has gone to their lawyers and said, what's happening to my dispute? Lawyers have said, I don't know, COVID, I don't know when I can get, I don't know when I can get your court case heard. And they've said, well, what else can you do for us? And lawyers in the UK have had to say, well, there is this thing called meditation or medication, or maybe it's mediation, I'm not sure, but we could try that. And so all of us who are active and mediate full-time as I do are seeing a huge uptake of mediation in areas which weren't being used before. So insurers use mediation a lot, but the construction industry didn't, but they've started to use it a lot more. And so what's going to happen is, if it keeps going as I think it was, this impetus will keep moving. And by that, when business, when commerce, whether it's local or whether it's overseas, that's when the government will say, okay, it is time now to ratify this. And I suspect that pressure will be put by other countries as well to ratify it. So I think it will happen. Not going to happen today, tomorrow. We've got enough problems. The government would say we have enough on our plate to deal with at the moment, but probably within the next 2 to 5 years, I see it. Fine, I'll just finish on one point. Because of the way our system works in the UK, and because the Singapore Convention, unlike the New York Convention, is not one of reciprocity, there is an argument that even though the UK has not signed or ratified it, the courts in the UK could still make use of it. So if you have a mediated settlement that has by some means a relevance to a country that has ratified it, but the subject matter or the parties are based in the UK, there is an argument that you could still use the courts to put it into place. It hasn't been done yet, but it's a possibility. The easiest thing will be to ratify it, of course. So that's a very long answer. I apologize for going on to the concise question, sir, that you asked as to why my government has not done it. Thank you.
Thank you, Mr. Melodis. But as we understand now from the talk that you said, that the government has, as of now, not acted on, and in next few years it may. So let's see about it, how it goes. But don't you, this of course a follow-up question as to, don't you think that signing that convention would help the businessmen and those who transact with other countries? They kind of comfort that the people in 2 countries which have signed this will get vis-a-vis those who are in England to transact with the business people in England and the European Union.
Yeah, I think the short answer is yes. It will definitely be of assistance to them. The difficulty is those business people don't know that.
Correct.
And until they know that, they won't be lobbying the government for them to ratify it. And that's that's the issue. So those, I always talk about who are the gatekeepers to mediation. It's the lawyers, and it needs the lawyers to see that this is going to help. As I said, I think we're quite, we have huge jurisdiction in the UK over legal matters, and I think that's the safety net that we have wide enforcement within the UK. We have ability to attempt enforcement overseas, etc. And so it all depends on the pressure. The government to do something there needs to be some encouragement, maybe some quid pro quo for them as well. And I think what's missing is on both sides. It's those who will benefit from it, knowing they'll benefit from it, and it's the government actually being persuaded, well, this is a sensible thing to do. For whatever reason, we take time to ratify conventions in the UK. We don't rush to do it. And I've never been in politics. I don't know the reason for it. I just know that's what happened, because it seems like to wait nearly 20 years to ratify the New York Convention doesn't appear to me to make any sense, when at the time London was already a leading arbitration center of the world.
Right.
So you're absolutely right, sir, that the benefit is clearly there, but it needs to be articulated by those to the relevant people in government, etc.
Right. Thank you. Next, we move to Ms. Sombold. Ms. Sombold, the question to you is, United States of America You're a pioneer in modern structured mediation and the world's largest trading community. The question is, what is the experience so far as settlement enforcement of these agreements are concerned, and have you faced any difficulties? You must unmute, I think.
There we go. Good. Yeah, thank you. Well, first of all, good evening, everyone. Good morning. It's 5 in the morning here in California, but I'm delighted to be here with all of you today. I love the Singapore Convention, and this is one of my favorite topics. Thank you to Bangalore International Mediation, Arbitration and Conciliation Center for the invitation and for organizing this great panel and conference. I truly believe that the Singapore Convention is one of the greatest developments in the history of modern mediation, and it will bring many benefits for international trade, for stakeholders, and for dispute resolution professionals. And that's what is one of my favorite things. But not only that, I believe the Singapore Convention is going to finally give credibility to the process of mediation at the international field level, because I believe that mediation wasn't given the value. It wasn't was like the ugly sister of arbitration, because in the global dispute resolution system, arbitration was the preferred process for dispute resolution, especially for international commercial disputes. And so I truly believe the Singapore Convention is finally gonna bring mediation up to the level, and it's gonna really promote the use of mediation across the world. And in regard to your question, yes, the US has been a pioneer in the modern structured mediation and one of the world's largest trading jurisdictions. And I'm proud to say that specifically California, in my home state, has the 5th largest economy in the world and one of the most progressive jurisdictions for mediation. As such, we really care about enforcement of international mediated settlement agreements. And how the parties do it here normally, well, we have to make the distinction between the enforcement of mediated agreements resulting from mediations that are conducted locally here in the state, and mediated agreements that are resulting from international mediations. So local mediations, as Andrew was mentioning, we don't have a problem enforcing it, because once the parties decide that they're going to go and try mediation, and by the way, here, at least in California, around 95% of the cases that get filed in court, they get resolved outside the court before going to trial. And they get resolved either through mediation or arbitration, 95%. And that's amazing. So just a small percent of cases ended up going to trial. And that's how much we use ADR, mediation and arbitration. But once the parties decide to go to mediation, that agreement is going to stand on 99% of the cases. They're going to follow out through the terms of the agreement. At the international level is a different story, because when you have an agreement resulting from international mediation, well, in case that one of the parties doesn't follow through, the creditor had to go and enforce it in a foreign court, and that was a big problem for international mediation agreements. So California specifically enacted as the California International Arbitration and Conciliation Act in 1988. And under the CIACA, that's how it's called, they treat a mediated agreement resulting from an international mediation as if it were a final arbitral award, just for enforcement purposes. And the whole point is to get the mediation agreement covered under the New York Convention. Because if we treated the mediation agreement as an arbitral award, the New York Convention will be applicable to that agreement, and it can be enforced under the New York Convention. And like everyone was mentioning, the New York Convention is basically the same thing that the Singapore Convention, but for arbitral awards. So that California enforce all the international mediation agreements resulting from mediation. And after 1 decade of this act of the SIACA, multiple jurisdictions in the US, like Texas, Ohio, North Carolina, and Oregon, follow California's example and enacted similar provisions to give a mediated agreement the same enforceability as a final arbitral award. At international level, I understand that multiple other countries, they treat a mediated agreement like an arbitral award just for enforcement purposes. And I understand that India had an act that's pretty similar to the one in California, and it's called the India Arbitration and Conciliation Ordinance. But in summary, with the Singapore Convention now, while the process of enforcement of agreements resulting from mediation will be uniform across all jurisdictions, and it will simplify the process and the enforcement process. And like I said, that will add a lot of credibility to the process of mediation, especially in the international dispute resolution process.
Right. That in substance, what you say is, notwithstanding the fact that you have not signed, but the point is there is no difficulty in enforcing this.
Well, the US have signed the Singapore Convention, that they haven't ratified it.
Right.
But we're working on it and really working on it. And we're hoping that the Senate ratify it. And like everybody was mentioning, well, we have the New York Convention that is supposed to be one of the most successful treaties in international trade, in the history of international trade. And it took basically from 1958, when it was adopted, it took 10 years to get it ratified by 10 countries. So, and after 63 years, finally it was ratified by 164 countries. Nowadays, it's ratified by 80% of countries in the world. So if we compare the New York Convention to the Singapore Convention is doing great. Because just with the first day when the opening ceremony in Singapore on August 7 of 2019, it was signed by 52 countries. 52 countries the first day. It took 10 years for the New York Convention to get 32 countries to sign it. So I think that the Singapore Convention is doing wonderful. And it's just a matter of time, and it's a matter to explaining to people that's the process. It takes time, and we have to be patient. Every government, it takes the time, and besides, we have COVID, and we have all the challenges that we have the last year. So every government was very busy doing something else and trying to handle the pandemic. So I believe that is gonna get there, and we're gonna get there, and it's gonna be ratified, and eventually, like the New York Convention, we're gonna have 80% of the countries in the world sign it and ratify it, and mediation is gonna be the preferred mode of dispute resolution for international commercial disputes.
Right. Thank you. Thank you. We now move to hear Mr. Lomesh. Good evening, Mr. Lomesh. Now, the question to you is, how do you think that India will benefit from this convention, and whether India has ratified signing?
Good evening, Honorable Justice Dinesh Kumar and all the esteemed panelists. Very good evening to all of you. I think India is going to benefit immensely from the convention. If you look at the legislation that India has developed the last couple of years, it's very clear that India has come up with legislations which are more pro-ADR. If you look at our arbitration space, for instance, there have been several amendments which the Indian Parliament has come about in order to make arbitrations more effective. Unfortunately, we do not have the Indian Mediation Act, which is something that the Honorable Supreme Court has also said that there needs to be some kind of a central legislation to ensure that the whole process of mediation in the country is standardized. But notwithstanding that, I think there has been a great impetus insofar as mediation is concerned in our country. And India stands to benefit immensely because, as the other panelists also pointed out, the world is shrinking today. And even in terms of disputes, at one point of time, I don't think people sitting and lawyers sitting out of Bangalore imagine that they would be involved in cross-border disputes. But today, sitting out of Bangalore, we have an opportunity to work on disputes arising from multiple jurisdictions. Because the world has shrunk, it has become a smaller place. Disputes have also become very local in that sense. And as some of the panelists have already pointed out, Singapore Mediation Convention was an absolute watershed moment. In fact, I was also one of the lucky few who managed to go there. And I can tell you it was an absolute spectacle to watch. Anna was also there. And this is something that I'm going to tell my grandchildren as well, that I was there at the convention, because it was just outstanding to see countries coming together with a common purpose of making mediation more progressive and more productive across the world, and to ensure that mediated agreements are enforced across the world, and including in India. Now, insofar as the Indian perspective is concerned, broadly, if I were to advise my client, and if I had to tell him that insofar as a cross-border dispute is concerned, what are the ways in which it can be enforced in India? There are obviously three methods. One is litigation, one is arbitration, and one is mediation. Now, under litigation, if there is a foreign judgment which has been passed by a foreign court, it has to be enforced in India under Section 13, read with Section 44 of the CPC. It has to be done only with a reciprocating territory. And there are not too many countries that India has notified as being a reciprocating territory. So there lies a problem there. Insofar as international arbitration is concerned, yes, India has taken a lot of strides in amending the 1996 Act by amendments in 2015 and 2019. But recent experiences, insofar as the Amazon dispute was concerned, where an interim order from a foreign arbitral tribunal, that is the SIC, where it had to be enforced in India, we saw that it led to a lot of challenges in the Indian scenario itself. So therefore, the legislative space, even insofar as international arbitration is concerned, needs to be amended to also bring in the enforcement of an emergency arbitral award also being enforced here, and also an interim foreign arbitral award to also be enforced in India. So the point really is that if you have a much better mechanism in mediation, where parties have the option of entering into a mediated settlement agreement, and if there is an international convention by which such mediated settlement agreements can be enforced in India, if I were to advise my client, I would certainly advise them to go for mediation a lot more now because of the seamless manner in which it can be enforced. So I would definitely think that it is an excellent opportunity for India also to rise above to the occasion and to meet the international standards by also getting domestic legislations in compliance with the Singapore Convention. Thank you.
Thank you. Now we move to the next question, and again, you have to answer that. This is with regard to the business houses, business enterprises in India who have cross-border disputes. So what are the best options to resolve the family disputes concerning family businesses, and which is the appropriate dispute resolution mechanism?
Thank you, Your Lordship. In fact, I would go to the definition of in the convention itself, because the whole topic is whether family disputes itself would fall within the convention or outside the convention. Right. Now, my reading of the convention is that, in fact, Article 2 says anything relating to family inheritance or employment law is what is excluded. The word used is family law and not family disputes. Right. So therefore, family law would have to be more restrictively read, because it is only cases which are pertaining specifically to family law legislations that would be out of the convention. In fact, family disputes, I would argue, it would be my argument that family disputes would something that would be covered in the convention itself, because there's a very thin line between family disputes and commercial disputes. Because you could have a family disputes which are arising from commercial interests itself, and that is something that would fall under the convention. That is point number one. The point number two is, in fact, I was reading a very interesting article by Jacob Lebowitz, in which he talks about how there is use of transformative mediation in resolving family disputes. Now you have the facilitative mediation, which is the traditional course. You have the evaluative mediation, where the mediator evaluates the pros and cons of the case. And you also have the transformative mediation, in which the mediator looks at the humane side of the entire dispute, gets to understand the psychology of the parties, gets to the genesis of what is the human interaction and human value in the particular dispute, and tries to resolve disputes. And the author also argues that this has been a tremendous hit, and that's something maybe that Anna also can speak about, that it has been an immense success in the United States as well. And that is something that can be adopted. And I'm also reminded of this quote in The Godfather, where Michael Corleone says that it's not personal, it's strictly business. Now, unfortunately, insofar as the family disputes are concerned, it is never only business, it also gets personal. And that is why I feel that family disputes are a lot more complicated to resolve, because it is just not business where you give and take something. You need to really understand the psychology and the emotions of a person, which is where I would say that transformative mediation is something that would really help in family disputes. I would go to the extent of also saying, this is my last point, I would also go to the extent of saying that if family disputes are treated as something which is commercial in nature, I would still go the traditional route of perhaps going before an arbitration center, which has an inbuilt mechanism of having an arbitration. From the arbitration, you can go to the mediator, and thereafter to the arb med arb, where you have the option of still going before a mediator and yet resolve your disputes. So, I mean, these are the broad points of logic.
So what you would, in substance, say is go before an arbitration center, basically, and then have an option of mediation.
That's right. That is one of the options. That is, if there is an arbitration agreement, parties would have no choice but to go and resolve the disputes through arbitration. But if there is no arbitration clause at all, then I would certainly say that mediation is something that can be looked at for this. And as I pointed out, transformative mediation is something that can certainly be used. In fact, from my own personal experience, when I appeared here before the Karnataka Arbitration Center, there was a retired High Court judge, and this was a dispute between the family members itself, pertaining to a commercial dispute. And for the longest time, there was so much of animosity between the parties. And I told my party to try mediation, to try settlement. None of that worked. But the retired judge was excellent insofar as understanding the pulse of the dispute was concerned. He went to the extent of making the parties stop the dispute while the proceedings were going on. And he made the parties literally share a hug while the case was going on. He told them the importance of forgetting about whatever happened in the past. And the parties gave the most reluctant hug that you can possibly imagine. But at the end of the day, just that one hug which happened between the parties, it was actually quite comical for all of us to see. But the end result was the parties broke down and they realized that this was something that was totally not called for. And they just needed somebody to make the party realize that the emotions are something which are more important than just looking at it from a purely commercial angle. And the matter got settled and the parties walked away happily.
Thank you.
Thank you very much.
Ms. Sombold, now the next question to you. This is again concerning the family business, and your expertise and your answer is solicited on where there are purely family dispute. Would it have an impact on the business and vice versa? And in your opinion, would you like to treat this as a family dispute or a business dispute?
Well, the thing is when there's so many family owned businesses and companies that they have members all over the world, and if they have a dispute, obviously we'll have to see what type of dispute it is, because if the dispute is related to a purely personal issue or related to an inheritance, and it gets resolved in mediation, the Singapore Convention doesn't apply, because as Mr. Lomesh mentioned, the first article of the Singapore Convention specifically excludes agreements concluded for personal, family, inheritance, or employment law issues. So any family dispute or inheritance, it will be excluded, and it won't be, and the Singapore Convention won't apply. Because we have to remember that Singapore Convention scope and application is very narrow. It does not apply to every settlement agreement resulting from mediation. The parties had to be in different countries. It had to be an international, and the parties have to go to mediation, and it has to be related to a commercial dispute. So those three elements have to be present in order for the Singapore Convention to apply. And we have to remember that the whole point of creating or developing the Singapore Convention was that the UNCITRAL, that is the core legal body of the United Nations, they wanted to promote international trade. And so this is not about family, or this is not about inheritance, or this is not about personal disputes or about employment law. They wanted to promote and unify the legal framework, and they wanted to improve international trade across different jurisdictions and across different countries. And they figured that by designing, by specifically just limiting the application to commercial disputes, that, by the way, that is exactly the same thing that the New York Convention did, just limiting to commercial disputes. Well, that will be more applicable, because I believe that if we start getting family and inheritance and employment law under the same thing, it will get very complicated. And remember, every country had to have their own, and they had to enact their own jurisdiction to apply and to just develop some type of legal framework to apply the Singapore Convention once they sign it and ratify it. So it gets really complicated, and that's why I believe that a family dispute, it won't be it won't apply. It will be totally different. So you have to really look at the heart of what the dispute is about and decide. But obviously, if there is a family own a big business or company, and they met the requirements of the Singapore Convention, I will take it to I would take it through the process if I have any problems with enforcement.
Right. So what you're saying, it's complicated. We'll now, at this point of time, leave it at that. Mr. Miller, what is the position in UK? Because UK also have several expats, and your experience in family dispute concerning businesses in UK, and particularly the cross-border.
So thank you, sir. If I can just start, just echoing what Anna has said and what Lomesh has said, I don't think it's any surprise that the Singapore Convention does not cover everything, because it simply couldn't. And I think in simple terms, taking out inheritance, divorce, immigration, and employment law, or rather not including it, was a sensible thing to do, because you couldn't cover everything. And the aim was commercial disputes. And what's interesting I've found is I in preparation for this, I tried to find any articles that would tell me how bad it was, or what a bad thing it was that those areas were not included. And I haven't been able to find one. So commentators don't think it's an issue itself. So you asked me about in the UK. Well, as a lawyer, most businesses start as family businesses when they start small, and Anna said the same. So it was never unusual for me in terms of dealing with disputes involve families. But the question was the nature of the dispute. That was the issue. It wasn't really the family. The personalities may have played a part in how you dealt with it, but the issue was identifying what type of dispute it was, what area it fell in, what area of law, what was the disciplines around it. And I think why that what it comes down to is simply because there's families does not prevent it being a commercial business dispute that will come within the realms of the Singapore Convention. And it makes sense because who are the best people to set up businesses? Well, it's people you trust. Who are generally the people you trust? That's generally members of your family. The downside, of course, is that families fall out. And that's why I think the commercial disputes, perhaps when people talk about family disputes, they talk about that because the falling out can be a lot bigger. The falling out is a lot bigger than, say, an insurer falling out with their insured over a claim. It becomes personal. But the personal side of it doesn't take away from the fact that at the end, there is a commercial dispute to be dealt with. But I think perhaps where your question is going is really what this is all about. Is can mediation serve a greater purpose than traditional litigation and arbitration? And the simple answer to that is yes. And again, if I can fall back, maybe a bit apologies, a bit like a scratch record if I bring COVID back into this. But I think what's one of the biggest problems? If you take business disputes that have got bigger, that sort of businesses that have got bigger and have become global, what happens is that you have members of the family acting in one country and one jurisdiction, some acting in another. And if there is friction, if there is a dispute, that is multiplied. And what you then have is how we're going to resolve that dispute. And you've got this conflict as to, well, I'm now in this jurisdiction. I now run the business in the US, but I run it in the UK. I want resolution in the UK. No, I want it in the US or India or wherever it is in the world. And you've got all these hurdles to jump even before you start dealing with it. And what mediation offers is it doesn't matter where you are. Mediation doesn't have boundaries and doesn't have boundaries in terms of geographical boundaries, because mediation can be done anywhere. And again, using the pandemic, what we've seen can be done at any time and can be done through this medium. And suddenly you have the ability to sidetrack all these difficulties that you might have in terms of which arbitral institution do we go to, which court do we go to, which country do we start in, and actually saying, look, you have a serious commercial dispute. It's small, medium, big, it doesn't matter, but you can start dealing with it. And what I say is, and I'm not the owner, I'm very much a proponent for early stage mediation. And there's no magic to those words. All it means is having a mediation sooner rather than later. And I've been asked in my talks in doing that. I remember one of the first talks I gave, someone in the back sort of shouted out to me, heckled me, where I was saying about how the sooner you can get to a mediation, the better. And someone said, are you seriously saying that it is never too early to mediate? And I remember having to think on my feet and saying, it may well be too early to achieve a settlement of a dispute, but it can never be too early for parties in dispute to start talking about why they're in dispute. And that's the key to mediation. And that you don't have that control of the narrative in litigation or in arbitration. But you have this huge control if you're willing to put it in the hands of the mediator to help you with it, to be able to start to have these discussions. And all these percentages, I don't do family, I only do commercial mediations. Whatever the percentage is that settle, and CEDAR often throws out 75, 85%. For me, that doesn't matter, because that's not what happens on the day. What happens on the day is, I would say, probably 50% settle, but that extra 25, 30%, a process has started. And they end up settling, sometimes within days, sometimes weeks, sometimes even, I've had one, I did the mediation in April, it effectively settled this week. because you start on a discussion process and you start on a thinking process and you start on a change of perception process. And that, that doesn't matter if it's big commerce or it's family business, small, medium, or large, that the same applies. So I think that's where mediation is going to really come into its own. The more it gets used, the more people will see is I have an ability to talk about my dispute rather than having others talk about it for me. And ultimately having a judge decided without me having any say. And the missing bit that is still missing is that bit that I talked about in my last one, is education, is people understanding that, whether it's a small case or a huge case. It's individuals understanding what this gives to them, because those of us who deal with it day in, day out know it. We know the magic of mediation.
Wonderful.
And that's what we have to spread. Thank you, sir.
Right. So your punchline is, sooner the mediation, the better it is. Good.
Sooner the better.
Right. So we move on to Mr. Meng, though the topic for you is to explain, are there any specific reasons to exclude family business disputes to keep them out of the scope of the convention? Kindly unmute.
Thank you. I want to make sure that I did not interrupt any of the other speakers when they were speaking.
Yes, yes.
Thank you. So I think that UNCITRAL, when it came together as different countries trying to agree on a single platform, a set of agreement, there are certain constraints. And as the other panelists have spoken, the focus is commercial, international business. How do we get everybody to agree on a set of enforcement? So that was the laser-like focus, which was why they were able to agree within a relatively short period. And there's also the thing, the consideration of public policy. As if you read the convention itself, you will see public policy being iterated again and again. And this cut across different countries. Of course, public policy may be different in the different countries. And this is, I believe, one reason why family disputes were highlighted together with inheritance, employment, personal law, etc., to be excluded. When you think about family, you think about things about custody, you think about maintenance agreements. So these are fairly domestic in nature. And I think the wisdom of the group was that it's best taken out of something as big as the Singapore Convention. But having said that, it doesn't mean that these should not be mediated. They should be mediated, but perhaps in terms of enforcement under the convention, not under the convention itself. And I want to echo what was said earlier, that the convention is obviously critical, but I think it was Mr. Miller, Andrew was saying that at the end of the day, parties don't really need to enforce it if they have agreed to it under a mediated agreement. And that's our experience in the Singapore International Mediation Center. I would say 99% of our cases do not have problems with enforcement. However, the psychological effect of the Singapore Convention being enforceable in an international arena is very helpful. It helps parties, it helps businesses to say, I want to mediate because at the end of the day, if I have to enforce it, I can. Not that I do need to, but if in the event I need to, I can. And for General Counsel, we can explain to our management that, after mediated agreement, we can enforce it. We don't have the embarrassing situation and saying that, oh, after the mediated agreement, the other side disagree, and we are stuck with going back to court. So that's really the thinking behind it. But having said that, right, I've had some of the most incredible experience mediating family cases. I think it was Mr. Lomesh who was talking about transformative mediation. We had a case where the parties came in the morning shouting four-letter words at each other, which I will not repeat on this podium, but it was really, really bad. They were almost at physical fights. But at the end of the one-day mediation, they gave each other a hug and they were almost, in tears. And that's the power of mediation. It's not just resolving that issue, but re-establishing that relationship between the parties. I've had other cases where, again, it's a family business, huge business with assets all over the world, and they think about the next generation. They think if as the elders in the family, we are fighting, how would that affect our children and the relationship between the children? And it was because of those considerations that these huge businesses, family owners, are able to agree that they can divide the assets in a way that is best, not for themselves, but for the sake of the next generation and the generation after that. And that's the power of the transformative mediation, to be able to resolve the issue that a court and arbitration may not be able to do so because of the constraints of the order. But with a creative mediator, you can find very good solutions, really, for the sake of many generations to come. So that's been our experience in terms of looking at personal inheritance cases, etc. It is something that can be mediated, even though it's not under the Singapore Convention. But again, I don't think enforcement is an issue in many of these cases.
Right. Thank you. Now, it's been very wonderful evening discussing so many things. We come to, in view of this pandemic, business to businesses disputes, it's very well known. Now, in view of the pandemic, this business to consumer disputes. So, what are your views on that, business to consumer? The resolution by way of mediation and the mechanism to resolve the disputes. Mr. Meng.
Sure, I think that business to consumer disputes have the possibility of mediation. However, you do have to consider the unequal bargaining position between the business and the consumer, right? Because you don't really have that equal bargaining position. However, it doesn't preclude mediation, because at the end of the day, mediation is about parties coming together to an agreement. So the consumer would be able to decide whether this is worth going further. And because of the nature of a lot of these disputes, I'll give example. I think many of you may be familiar with the eBay Resolution Center, where they use AI as a way to help parties to resolve such disputes. I think there's a very good example where disputes can be resolved very quickly and can be enforced, so to speak, very quickly because of the financial arrangement that's already been in place, credit card, etc. And that will help very quickly the parties to resolve issues that may take a long time and may cause a lot of problems. So I think there's a lot of opportunity for that. And within Singapore itself, with other organizations that are specifically set up to help consumers take up cases against manufacturers, against sellers, distributors, etc., and try to even out the playing field for mediation to be successful.
Yes, very important point you made about the bargaining positions of the two parties. So a kind of social justice, a balance has to be struck in such kind of cases. So would you suggest that this scope also must be included into the Singapore Convention?
I think the Singapore Convention again is probably wide enough, because if you look at the definition of commercial under the convention itself, the Armstrong Model Law, the footnote actually gives a definition of commercial. It says all relationships of a commercial nature, right? So it's very, very broad.
Very wide.
Very wide. So in that sense, I think one could possibly argue that it is commercial. And if it is cross-border, I think that's what Anna was saying, it has to be of international nature, then it probably could come under that.
Correct. Comments of other panelists, Mr. Andrew and Sombold and Mr. Lomesh, in the same order on this issue about B2B model and B2C model, Mr. Andrew?
Well, I don't see why there's any difference in terms of it being a commercial dispute. There are many businesses dealing with consumers that would prefer their disputes to be dealt with outside the courts. And so mediation is used. There are group actions where that has occurred. They don't want a finding against them, and they prefer to settle a case at mediation. So I think there is nothing different about that. It is a commercial dispute. You of course have the unequal bargaining power, but you can have that in any dispute, and that's something a mediator has to be alive to. I think there's one thing that is a potential issue here in mediation. And that's a question, I'm thinking what is the right way to describe it, but I think probably an ethical question. So I will give you sort of an example. You may have the case of an individual who is driving his car, who ends up in an accident and prangs his car around a tree. And that accident has occurred because of a fault in the motor car. Absolutely no fault on his part. So he sues the car manufacturer in respect of that fault. And the car manufacturer wants to go to mediation to settle it. And at mediation, the car manufacturer offers a full settlement, let's say the full amount of the damages, maybe some compensation for personal injuries. But what happens in that mediation when the parties, or more important, the mediator, learns that that fault in the car is also a fault that is likely to be in another 10 cars that were produced, or 100 cars, or 1,000 cars, or 100,000 cars? What then happens? Because you're then faced with this is the inequality of bargaining power. You're faced with a situation of business against small consumer, of wanting to push it obviously under the carpet. And that raises a lot of ethical questions and extremely difficult questions for mediators. If a mediator comes across a situation where they know, for example, that there are potentially, let's say, 10,000 other drivers out there who may not just prang the car, but may end up themselves seriously injured, dead, or indeed, other individuals. And so it's a bit of a sideline, but it's something that as mediators, you have to be aware. I know mediators who are far more senior to me, who have had similar sort of incidents as that. The one I said, I'll make perfectly clear, is fictional. I made it up myself. But I know of mediators who have had them, some involving personal injury actions, some involve historical abuse claims, etc. And that's the sort of thing that I don't have the answer to, but when you're thinking about big business against small consumer, it's something to bear in mind. But in terms of the Singapore Convention and in terms of mediation itself, for me, there's no reason why it can't be used.
Sure. Anna, Miss
Well,
Anna.
Yeah, well, if we talk about business to consumer in the US, well, the preferred process to resolve disputes is consumer arbitration, no litigation and no mediation. And the reason of why, well, when you have a huge company like Amazon, and they have tons of disputes, and so obviously in every transaction, they're always going to include an arbitration clause, because the company, they don't want to take it to litigation because it's going to be super expensive to take every single complaint or dispute to litigation. Or they don't want to take it to mediation because in mediation, they won't have finality. The mediator, at least here in the States, they don't have the authority to impose something on the parties. So if the parties, they don't agree, they don't reach an agreement, the dispute will drag over and longer, and they may be adding another layer of litigation to the process. So that's why normally big companies, they always have an arbitration clause. But what they do is they have expedited a process for consumer cases, and the company normally pays the fees of the arbitrator, and they have a limit on the number of days that the hearing can take over. And I have done tons of consumer arbitration cases, and what I see sometimes in between, I see the disparity between the consumer and the representative of the big company. I see it all the time. And it's very difficult for an arbitrator, because as an arbitrator, you're not supposed to give legal advice to the consumer. You're not supposed to tell the consumer how to represent themselves in the arbitration hearing. But at the same time, I see from the side of the company that with arbitration, they're gonna finally have an award at the end from the arbitrator, and they're gonna have finality of the case. And normally the arbitral awards they can be appealed. So it provides a warranty to the company that the dispute won't drag any longer. Another interesting program that I saw, a company here in the States, they have a mediation arbitration program. So they had a clause in every single contract with consumers. And so what we did is we did the mediation. They limit the number of mediation hours to 2 hours. And if in 2 hours we didn't resolve the case, the mediator it become an arbitrator, and they impose or they decide the case. I thought that was very effective, because I had the chance to talk to the consumer, and it wasn't restrictive as in an arbitration hearing. And at the end of the 2 hours, if the parties didn't reach an agreement, I will decide after hearing the two of them. So I thought that was the perfect solution for the company and for the consumer, because the company will get finality and the consumer will get some type of informal process and an opportunity to resolve the case, and opportunity to talk about what they would like in lay terms and in a simplified process. And so I think so mediation arbitration, that would be the perfect way to resolve business to consumer disputes.
Thank you. Mr. Lomesh?
Yeah, thank you. I have a slightly different take on this, a slightly different kind of an approach to this. There is no doubt that the commercial transactions that are taking place, in terms of e-commerce, that have exponentially increased over a period of time. Just to give us statistics from a United Nations report itself, in 2019, B2B and B2C, the transactions were $26.7 trillion. And B2C was $4.9 trillion. And India stood at number 9 at $61 billion. And these transactions are only going to increase. Now, what happens with increase in commerce is obviously the disputes are also going to increase. Now, if you're looking at effective means of resolving this, and if you're saying all of this has to go before a mediator, which by the very definition of what a mediator and a mediation process is, has to be an independent party. And if these are all commercial transactions, let's say on Amazon, you purchase a shirt for 100 rupees, or if it is just something which is not more than a few dollars, to have everything to go before a mediator is going to be extremely time consuming, also not going to be cost effective for the company. So I think what the companies would be better advised to do is to have an in-house mechanism in which a lot of these disputes can be resolved in-house without the necessity for it to go to the next stage of either going before arbitration, like what Hannah mentioned, or before a mediator, because that'll literally, like out of 100 cases of consumer cases or consumer disputes that are raised, 98 or 99 could be settled, and only those 1 or 2 cases where the cases could not be settled by an in-house mechanism, it can perhaps go before a mediator. Now, the problem with sending everything before the mediation also is that where is the pool of mediators? Do we have sufficient pool of mediators? Do we have enough infrastructure in place to ensure that all of this can be handled by, let's say, a private mediation center where you have dozens and dozens of cases just being flooded? And in the guise of, we talk about social justice through mediation, where if an institute or if a mediator is flooded with several cases, will there be social justice, or will there be just a tendency to rush through the whole process of just disposing of the cases where ultimately social justice is what will suffer. So I would say that it's better to have an inbuilt mechanism where the companies deal with it without the necessity of going to a next layer. Suppose it does not settle at that particular in-house stage, then obviously you go to the next stage and go to mediation, because mediation, I would say, would be a lot more cheaper experience from an Indian context compared to an arbitration process.
Good. So different views there, different experienced people. Thank you very much to everyone for your thoughts and your brilliant inputs on the subject and your opinions on this. I'm sure that the viewers will have the benefit of the experience of all the panelists and world over how the things are taken, and in particularly in UK and EU when they will join. And about the B2C, of course, there is a kind of different opinions, and we will leave it at that for the different jurisdictions to handle. From my side, I'm always been and continue to be with the mediation, because I believe that peace is more valuable than anything else in life. And for the last maybe about 15 years, I've been seriously working on this. Even now, of course, on last few years as a judge, even here I use mediation as much possible. So, and I also have had experience of parties going with great amount of satisfaction and with smile on their face, and relations having been kept intact. Thank you very much, and thanks to BIMAC to have invited me to be a part of it in this program. And thank you very much for your patience on this. Thanks.
Thank you, everyone.
Thank you. Thanks.
Thank you. It's a pleasure. Kumar.
Thank you very much for this session. These discussions have been very insightful, and I'm sure all our viewers echo the thoughts of Justice Dinesh Kumar. Thank you so much, sir, for agreeing to be a moderator. And thank you to all our wonderful panelists for bringing in international as well as domestic perspectives on this issue. I now would like to request my colleague and team member, Ms. Siri Prasad, to talk about the next session.
Hello, am I audible, Ramya?
Yes, you are.
Hi, everybody. Good evening. So we'll be taking a wellness break of 5 minutes, and we will be reporting back at 7 p.m. sharp, and we will get started with session 3. Thank you.
Thank you.
Thank you.
Nice to see you, Lomesh.
Absolute pleasure. Thanks, Andrew, for accepting the invite and joining us. It was really lovely hearing you. Thank you very much.
Pleasure. Nice hearing all of you. Thanks so much. Enjoy it.
Thanks on behalf of BIMAC. Thank you for your participation. And Anna, I don't know whether she's there. Anna, thanks a lot. It must be very, very early in the morning. I troubled you a lot. And
Looks like
Lomesh.
Anna's left.
Yeah, you've been wonderful, all of you. And Lomesh, thanks a lot. And
my pleasure, sir. Thank you.
Andrew into this panel, and and Weaving us also left, is it? Okay, it threw a lot of light on the program. So have a nice day.
Tomorrow in the match.
Oh, thank you, and best wishes to you too.
Take care.
Bye-bye.
Hope to see you,
Take care. See you
in India sometime soon.
Absolutely. It'll be nice to meet you, Andrew.
Yeah, when all this is past. Well, I was meant to be coming back out again in January to judge one of the mediation competitions again, but let's see if it happens next January. Yeah.
Sure. It'd be nice to meet you when you do
I
come
see
down.
your numbers are now going down. Our numbers are now going up.
Yeah, it's a cycle, I guess.
Yeah. We'll see. Okay.
Okay, take care. See you.
Great
Bye.
section. Take care.
Thank you, Mr. Thiruvengadam. Thank you. Thanks for having me here. Bye.
Hi, Thiru. I'd like permission to share the screen later when my presentation comes, please.
Yes, sir, sure.
Yes.
Hello,
Thiru. How are you?
How are you?
Let's not have a share. Hello, Thiru. Can you hear me?
Dr. Natalia, it's wonderful to have you, but your audio isn't very clear. I think
I will adjust it. Just a moment.
Sure.
Is it better? Is it better?
It's
no, not really, ma'am.
There's some disturbance, Natalia. How do you do anyway? Welcome. Hi, Nadja. Welcome. Thanks a lot for accepting my invitation.
Hi, thank you for inviting me. Can you hear me?
Yeah,
Yes,
clear.
ma'am.
Okay.
Loud and clear.
Thank you.
Lawrence joined? Hi, Hi, Lawrence.
Hi. Je bouge pas. Okay. Hi, everybody.
Hello,
Hi.
ma'am.
Okay. Now I'm going to exit.
Hi.
So the floor is yours. Okay. So I'm looking forward to hear all of you speak. The previous session was very interesting, threw a lot of light, dispelled so many misconceptions people had about the Singapore Convention. The entire purpose was to clarify this. In fact, Wei Ming and I had a discussion. I said, no, this is done intentionally so that people should understand what really they should expect from the convention. Yeah. Hi, Lawrence. I think your video is frozen here too. Take care.
Yes. I know I'm in Greece and it's not, the network is not so good.
Oh, okay.
Yes.
Niranjan, bye. Welcome.
Hello everyone. Hello, Nadja, madam. Nice
Hello,
meeting
sir.
you after a long time.
Hello. I haven't seen you in so long.
Yeah.
Wonderful to see you.
Yeah, my pleasure. Natalia,
Like old times.
we had met at Vienna.
We had? Yes, yes. Yeah.
I distinctly remember you, and we had a good conference at Vienna.
Oh, we had a great time.
And after many, many years, it's a pleasure to be with you again.
Likewise, likewise. I'm very happy. Yeah. Very happy to be sharing the panel under your moderation.
Yeah, thank you.
Yes.
Niranjan is one of the most respected mediator, pioneer in India as such, highly respected.
Well, you're too generous.
No, it's being honest, totally honest.
Yeah. In fact, we are in midst of very learned people from different countries of the world, from whom we have to gain a lot, understand a lot of things. And I'm sure today will be the first of its kind, many more meetings to follow.
Let's hope so. Yeah, I think it'll be really interesting. I'm looking forward to the discussion.
Yeah.
Nadja, it must be late for you in the evening, so my apologies.
Yeah, 9:30. Yeah, no problem. 9:30.
Appreciate your presence. And yeah, we had Anna joining at the previous session at 5 in the morning. I felt
Oh
so
my gosh.
Yeah,
Oh.
5 in the morning.
No, I'd rather be in the evening. It's okay. I'm quite happy.
It must be quite late for Professor Nadja.
Must be
It's not too late. 9:30 p.m.
We are going to keep you awake for a long time this night.
But the conversation will be so inspiring. I won't be able to sleep.
I don't see Lawrence on the. Do I see? Miss.
I'm here, but the picture is a little frozen.
Yeah.
Yes, ma'am.
Good.
We'll just get started in the next 1 minute.
Yes. Je vais mettre directement le PowerPoint dessus.
Okay. I think we are good to go. We'll get started.
Yeah, fine. All panelists are on.
Yes. Hello. Am I audible?
Yeah.
Yes, you're audible.
Hello, everybody. I'm Siri Prasad. I'm an Indian qualified advocate enrolled at the Karnataka State Bar Council and an accredited commercial mediator having trained at BIMAC. I extend a very warm welcome to all our esteemed guests, moderators, speakers, and participants. I consider it a privilege and honor to introduce our moderator and speakers for session 3, which is on the topic Standardizing Mediation Training. The moderator for this session is Mr. Niranjan J. Bhatt. Sir is a lawyer practicing in the Gujarat High Court for the last 64 years. He was a member of the Indo-US Study Group for Reforms in Civil Justice System. Mr. Bhatt is a master trainer in mediation and also the member of the expert committee appointed by Mediation and Council Project Committee of Supreme Court of India. We welcome you, sir. Our first speaker for today is Dr. Nadja Alexander. Ma'am is a professor and director of Singapore International Dispute Resolution Academy and is a practicing advocate having an experience of 3 decades and having practiced in more than 40 jurisdictions. Dr. Alexander is an award-winning mediator and commentator. It's a pleasure to have you with us, ma'am. Welcome. Our second speaker for this evening is Ms. Lawrence Barada. Ma'am is a lawyer, mediator, director at IHEMN University of Mediation and Negotiation. Ma'am is the president of Polo Sud Mediation Center and vice president of French Federation of Mediation Center. We welcome you, ma'am. Our third speaker is Dr. Natalia Gadanko. Ma'am is a Russian lawyer and an international commercial mediator. She was a member of the official Russian delegation at UNCITRAL from 2016 to 2018. She's a member of panel of mediators at the Chamber of Commerce and Industry of Russian Federation. Thank you so much for coming here, ma'am, and we welcome you. Our final speaker for this evening is our very own Mr. Shiv Kumar. Sir is a lawyer with a standing of 5 decades at the Bar of Karnataka. He's the founder-treasurer of Consumer Care Society. He's a certified mediator and master trainer at BIMAC since 2010. And has trained hundreds of advocates and judges in mediation and conflict management. Thank you for being with us today, sir, and we welcome you. I hope all of us enjoyed the session, and I'm sure we will have a lot to take back home. So now over to you, Niranjan, sir. You can take it forward from here. Thank you so much.
Yeah, welcome all my friends and panelists. In fact, I had worked out a little change in the order of speakers, and I contacted them all and taken their assent and consent for the order of the speakers. As a moderator of session 3 of technical session on this conference on standardizing mediation, I welcome all this in this evening, all experts around the world, Professor Nadja Alexander, Dr. Natalia Gadanko, Ms. Lawrence Bardatta, and our Indian friend Shiv Kumar, who are all going to share with us their expert knowledge on this very important and useful subject, standardizing mediation. During this about 1 hour, they are all going to share with us mediation scenario in their respective countries and their mediation experience. India had lost its ancestral mediation philosophy with the advent of British colonial rule. and Anglo-Saxon law replaced ancestral mediation concept of organizing three words on which mediation was based, namely wisdom, reason, and prudence. Now, mediation is revived in India with global innovation. Today, mediation has become a world phenomenon. Therefore, BIMEC has rightly invited learned scholars from Russia, France, Singapore, and India to acquaint us with how mediation prevails in different countries, how mediation education, mediation syllabus, training programs, and standardization thereof is prevailing in different countries, which will be of immense benefit to us. I would first invite a unique personality whom I met in Vienna some years back in a conference. This lawyer cum mediator has specialized in commercial law. She has a PhD in comparative company law. She is an accredited international mediator and an accomplished mediation trainer. She is a member of the official Russian delegation. Am I audible to all, friends?
Yes. Yes.
Yes. Yes. Now I invite our friend from Russia.
Thank you very much, Mr. Bhatt.
Yes, I welcome you to please enlighten us with your knowledge and expertise. Thank you.
Thank you very much for inviting me. Thanks to the organizers for having me here with you. I will show you how it works in Russia and what problems we experience here with mediation training. I will share my screen just a moment.
Dr. Natalia, your audio still has a few disturbances. It's not very clear. I thought I'd just let you know that. We could hear and understand what you were saying, but there was quite a bit of disturbance. I think
I'm afraid that I cannot. Just a moment. Do you hear me better?
I think
Is it better?
I think it's a problem with the mic.
I think it might be better without the microphone.
Without the microphone.
Because I think the frequency is what is causing the disturbance.
Is it better?
No, there's still a bit of disturbance, unfortunately.
Nothing to do, I'm afraid. Can you provide me with demonstration of screen?
Sure.
Because now it's switched off. Thank you.
Ok. Elle a partagé l'écran. Ah oui, elle a demandé à ce qu'on partage l'écran. D'accord.
Okay. Can you hear me at least somehow?
Yes.
So I switch it off and continue with my camera. Please show the second one. The second slide. We as lawyers go first to the sources of mediation. Unlike many other countries, we have a special law on mediation, and it is in force since 2011. So it is already 10 years experience of mediation, of legally approved mediation in Russia. How do we train mediators? It is a very difficult question, and I will explain to you why it is so. In fact, in Russia, mediation is a profession, and we even have a special professional standard of mediation. And moving from these requirements set off in this professional standard, we work out the programs for training mediators. Yes. Next slide, please.
Next slide.
Okay. What is a professional mediator under Russian law? This is a person with full legal capacity, with completed higher education in any field, not necessarily a lawyer, 25 years old, without criminal record, and with completed course of continuous professional education in mediation. And please note that any retired judge in Russia may be mediator without undergoing any professional training. That's also a very specific thing. But spoken to our judges and they told me, no, we cannot do it without any training because our functions were to settle, not to settle, but to resolve the dispute on the basis of law. And we may not deal with all these emotional things, all these interpersonal relationships. We need additional training despite of the fact that we are not obliged to. Next slide, please. So what is a professional standard? We have here the small one that's mediator generalist. That's the basic training that lasts for 120 hours. We have specialized mediator who learns more, twice more actually than the basic mediator. And finally, we have the big one, the big doll, big supervisor, who may not only supervise but also teach. Next slide, please. What is a professional standard? What are the requirements? Mediator generalist, so the basic one, without any specialization, must be bachelor and have additional professional training. Specialized mediator must be something more, so it's already a magister plus 2 years of experience on the field of specialization he or she has chosen, plus additional professional training. So it is a higher level of skills, higher level of education, which is expected from him. And finally, supervisor is the top of mediator professional standard. That's the one who has gone all through these 2 steps from mediator generalist to specialized mediator and had not only additional professional training, but 7 years in mediation and 3 of them in the area of specialization. Next slide, please. So what are the sets of skills required or expected from all these people? Next slide, please. Next slide. Okay, thank you. That's what can do and what should do and what should be able to do the mediator generalist. He must know the principles of mediation, must be aware of the mediator roles and of the roles of the parties. So he must be able to explain why the parties should go to mediation and what they are expected to do there. He or she must be able to conduct mediation procedure and to know something about law in order to draft all the documents accompanying the mediation from the beginning to the end. Mediator generalist must be aware of intercultural things, be familiar with psychology and negotiation theory, and understand some basis of social communication. So this mediator generalist learns for 120 hours. Next slide, please. What is a specialized mediator? He must know the same things that a generalist has, but in addition to that, he must be aware of some special things in psychology, most deeply understand some interpersonal relationship, emotional work, and understand how to deal and how to go to common solution. Next slide, please. What is supervisor? That's the same thing, that's specialized. But in addition, he must be able to analyze practical cases and understand psychology of education and be able not only to assess, to supervise the activities of the colleagues, but ability to teach, to show what was not so good, what could be improved, and show how to do it. So that's supervisor. Next slide, please. Standards of training. We have quite a story with standards of training. Since from the beginning of, from the enactment of law on mediation in 2011 till June 2017, we had a program by Ministry of Education. Basic course, 120 hours, special course, more than 200 hours, and trainer's course. Now, this program is no longer in force. And each organization, each individual wishing to train in mediation is free to do it. And now we have different courses starting from 40 hours, 90 hours, 120 hours, 250 hours, whatever you wish, in whatever format. But most of my colleagues, trainers, believe that 120 hours is the minimum which is required to have a working specialist who is already able to mediate, to conduct mediation, to help people into mediation, and to work after that into the field of specialization. Next slide, please. Basic course is composed of 3 parts: introduction, procedure, and mediative approach. That says nothing, but these 3 parts correspond to the professional standard description. Next slide, please. Specialization. You may choose family, commercial, intercultural, restorative, multiple. And this program is to be completed within 5 years from the completion of basic course. Next slide, please. Trainer mediator is 90 hours, and it is mostly for teachers. These are andragogics. This is time management, what is required from coach to trainer. Next slide, please. From my experience, I may tell you that 120 hours are sufficient to start. And I could recommend it as a basis. Online training is okay. On COVID era, we have trained several groups already. And there is a big difference between training offline and online, which was discussed during the first session. But we got used to it, and people who are trained by us already work, and it functions, and they do online mediation. What is missing in this beautiful scheme? Mentoring programs. Once you have a fresh mediator who has completed 120 hours of experience of training, he doesn't know where to go and how to teach, how to find a mentor, how to find a supervisor who would help him into the profession. And I think that this is a very big problem. We must do something with that, and it seems that our Ministry of Justice starts working on it. Next slide, please. So, the most important thing now, after the Singapore Convention, is to have the standards of qualification recognition. And I'm very happy that we have here in our panel the distinguished people who have lots of training experience, with whom we may exchange and probably draft some general lines on which we could agree for standards of qualification recognition. Next slide, please. After Singapore Convention, on the agenda we have the issue of cooperation between institutions organizing and administering mediation. And we must know whom they are admitting as professional mediators doing with difficult disputes how we may be sure of their qualification. So for this ends, we need a unified code of ethics and the standards of recognition of qualification. That's why sharing our national system of certification of mediators may help to create unified sets of qualification and skills and work them out together with international organizations based on the feedback from the users, like IMI from. Next slide, please. So that's something I would like to suggest to you. Let's share experience, unify criteria of recognition, and I would like really our international family of professional mediators grow. Next slide, please. Should you have any question, please write as you did for previous sessions. And the final slide, please. Thank you.
Thank you very much, Natalia. Would you mind if we reserve questions at the end of the session when everyone has spoken, so that we'll hear all of them initially, and then we'll go to specific questions. I have a few questions for you, but later on I'll ask. Is it okay with you? Is that okay?
Yes.
Thank you. Thank you very much. I appreciate your presentation. It's quite in detail, and we have to learn a lot from what you have said, and we'll try to understand more about it with the going of the time. Now, ladies and gentlemen, I invite another lady who is a specialized mediator from Paris in France, Laurence Baradat. She's a lawyer mediator practicing in the area of corporate business and family law. She holds a bachelor's degree in business law and auditing, a master's degree in psychology, which is a unique example, and a diploma in mediation. She is a director of University, Nîmes University, and vice president of French Federation of Mediation Centers. She was in charge of national training of mediators and in charge of international development. She will speak on standardization of mediation, quality of mediators, psychology in general. She is a president of Mediation Center, and we now invite Florence Baradat to address us. Please.
Yes.
Welcome.
Okay. Thank you very much. Do you hear me? Yes.
Yes.
Ah, okay. Okay. Well, I'm going to start my presentation about standardizing mediation training. Well, is it possible to have next slide? Next slide. Thank you. Well, it's my picture, but we can. You said, well, I just want to say that I was vice president of FFCM, French Federation of Mediation Centers. And I am not president of Nîmes University. I am director of IHEMN, Institute of High Studies in Mediation and Negotiation. But we work with Nîmes University, and we have a diploma with IHEMN Nîmes University. I just want to say that. Well, next slide, please. Thank you. Standardizing mediation training. Well, what does it mean? I think we can see what does it mean exactly. Is it about program? Do we have to standardize program? How many hours? Do we have to standardize contents, the subjects? What about trainers? Who are there? What do we want to teach them to teach? Is it about certified schools, certified institute, habilitation, obligation? Well, I think that we have to know what we are speaking about. So next slide, please. what I want to say, I'm going to tell you what we did in France, and then after I'm going to imagine questions. So what did we do in France in order to standardize mediation training? In France, we started to standardize mediation training in 2004 inside the FFCM. So it's a long time ago. And FFCM is a federation of centers, and you have about 60 centers in the FFCM and about 2,000 mediators. So we have to harmonize. It was very important for us to harmonize training. The program, so we presented a program, and the program has been voted by the General Assembly of FFCM in 2008. What was in this program? Well, we defined the program, the contents in the program, and criteria for trainers, and criteria also for certified schools or resolution institutes who wanted to teach negotiation. We also have created a training book for each mediator, which is called in French Livret de formation du médiateur, but in English, it was each mediator can write each training he does, he did. Okay, next slide. Okay, thank you very much. What about the program we introduced and duration? The program. We have structured the program and in a basic training and an advanced training. It's just like Natalia. We haven't the same hours, but it looks like a little the same thing. Basic training, 40 hours, and advanced training. But we have also specialization in family mediation and mediation for companies. You also have in France social mediation, but we don't do this for professional, because these programs are done for professional mediators. And social mediation in France, they are not professional mediators. They have training, but they are not professional mediators. Next slide, please. Is it possible to have next slide? Thank you very much. What about the content? We sought out a lot of, and we think, and according to us, it's not according to us, we put this. Mediation, we have to teach mediation in general, process of resolution conflict, I will say something after, posture and qualities of mediator, a little negotiation, because mediation and negotiation are not the same thing, mediation law, psychology in general, but also communication and relationship. And we say in France, dimension of relationship dimension. We also have emotional dimension and promoting mediation. And next slide, please. I take one example. Every module has been thought out, but I take an example in general mediation. Of course, you have subject inside theater. For example, we are going to teach what are the difference between conflict resolution and amicable resolution with judicial resolution. How does conflict start? How does it grow? How it can be resolved? History of mediation and philosophy more than history. The principle of mediation, impartiality, neutrality, independence, and negotiator posture versus mediator's posture, and things like this. But I will take another example of another module. Next slide, please. May I have the next slide, please? Thank you very much. Every module has been, as I said, deeply thought out, and this one, conflict resolution process, is a very important module. Conflict resolution process is not a simple process used with a toolbox. You don't have only a tool or tools, and you can't take a tool and when you want, I take a tool, or when I want, I take another tool. No, it's not that way. You have a process, and the mediator knows exactly where he's going, where is he in the process. He knows at all time where is he in the process. He knows where he is in the conflict and where he's going. He's not led by people, you know, where when you are in a mediation, people can cry or they can laugh or something, but you don't. Mediator is absorbed by his job, and he leads people constructively. He brings them to build constructive and creative solutions to go beyond the conflict. He calms them, of course. He helps them to build relationship, but it's not his principal, his main job. There are very precise dimension, phase, goals, and steps in the process. The mediator must use the right tool at the right time. The mediator should always know what dimension, phase, or tool he has to use and at what time to use them. So the process is very complex, but what we understood is that this process allows us to manage difficult conflicts and to achieve extraordinary quality agreements. And if you use this process, it's very, very, very important, and you can have extraordinary quality agreements. May I have next slide, please? Thank you. Duration, it was a question. Do we have to have a training of 40 hours or 200 hours? It was a question. And if you have a very simple process, of course, you can have 40 hours. But if you have to explain phase, dimension, steps, tools, it's more complex. And when you have to explain everything, these things, it's not you have to have more time. May I have next slide, please? So if you have a simple process, you can be with 60 hours. But if you have to explain a complex process, you have 200 hours. Next slide, please. We sort out. We think about other criteria like 50% practice when you have a training, one trainer for 12 or 15 to 50 maximum, and pedagogy. Pedagogy is fundamental, interactive, experiential. Pedagogy is very important, and as I have told you, we created a personal training book where each mediator can take notes of all the training it does. Thank you. Can you have next slide? Next slide. Thank you. And also we did a certified to resolution schools or institutes. They have to prove that they respect the criteria above. Next slide, please. So what is important is the future. What is it possible to do tomorrow in order to standardize mediation training in the world? But do we have to standardize, and why? And if yes, how do we are going to standardize? Next slide, please. Why standardize? Because it is a guarantee. We saw it in France. I saw it all over the world because I have been in Benin, I have been in Congo, I have been always, I've been in a lot of countries. And it is a guarantee for prescriptors, judges, companies, citizens, and for agreements of the best possible quality. For international mediation to have an international certification. The principle, the more important is, if you want to choose a good mediator, you have to know who he is. And if you don't know who he is, you can't choose him. So if you have a guarantee, of how he has been trained, it's better, it's better. Next slide, please. How to standardize? Are you going to ask ourselves the same questions that we asked ourselves 20 years ago? Maybe we have to think about programs, contents, criteria for trainers, for certifying schools, resolution institutes, and so on. Next slide, please. Who will standardize? What I think, Natalia, I think, we have to meet ourselves, to meet together, to share our knowledge and to build international standards in mediation training. We have to propose something. I think we have to share, to be together and to think and to know, because I don't know what you know. I know what I teach, but I don't know what you teach. And it's important to be together and to say and to have a committee. And then we can assure minimal quality, but we can also assure maximal quality of mediation agreement around the world if you are going to be together. So I think we have to create committees to do that and build these programs, contents, certification criteria, and so on. Next slide, please. And how to really standardize. Everything has to be done. Everything has to be done. Next slide. Thank you. Thank you for your attention.
Thank you. Thank you. It was a very enlightening explanation, and we found that you have a very, very deep and prolonged training programs. We'll invite further questions. Presently, I would invite the next panelist, a professor whose name is most respected in mediation world. She has specialized in cross-cultural disputes involving corporations, countries, and communities. She is a professional having 3 decades of engagement in 40 jurisdictions. She has been the user of online dispute resolution technology. She is involved in designing dispute resolution systems, conflict coaching, and has been advising as in a mediation law and for policy making in mediation. She maintains mediator credential status in Singapore, Hong Kong, and Australia. She is an award-winning commentator and mediation trainer. She has trained and coached more than 4,000 people in accreditation and certification programs around the world. She has contributed to regulatory and institutional systems in more than 10 countries. In 2020, she was appointed to International Advisory Board of newly formed United Nations. She holds positions in law firms, management, consultancy, universities, international organizations, and has worked throughout Europe, Asia, and Pacific, also in Middle East and North America. She is a director of Singapore International Dispute Resolution Academy. I am very proud to share that I met her long time back in Australia, and in recent past, she visited India at Chandigarh, where I could meet her. I'm looking forward, Ms. Alexander Nadja ji, Doctor, Professor, we welcome you, and we are very keen to listen to your expert knowledge. Thank you. Please guide us.
Thank you for your very kind introduction. It's such a pleasure to be on this panel, personally also with you, Niranjan, again. And thank you very much also to BIMAC for organizing this very interesting and diverse conversation. Now, am I able to share my screen? I think I am. I'm going to try and do that. So just bear with me.
So you should be able to share your screen.
Great. Oh, let me just give me a split second. Host disabled participant screen sharing.
I'll just try and rectify that immediately. Sorry.
That's all right. Bear with me, everyone. Just be a second. It's just got the same dialog box. Right. Should I start and just let me know when you've enabled it?
Yeah.
Yeah, all right. So it looks like I can't, at this stage, I can't share my screen, but if that changes, somebody will let me know. So I'll just start without it and you'll just have to look at me. I wanted to do a couple of things, not talk about any particular jurisdiction, but draw on examples from some different parts of the world and perhaps also refer back to the previous speakers. And I wanted to talk about three things, if you like: context, structure, and then offer some illustrations as well. Because I think, like in terms of context, and this has been mentioned, I think, in the previous panel a lot and a few times already here, the Singapore Convention on Mediation has been a milestone. And yes, it puts mediation on the international map, but in particular for training, I think it's very important. And for us to look at this issue of standardization or not and what everyone's doing. And it's important because one of the grounds for refusing to directly enforce an international mediated settlement agreement under the convention relates to or involves a alleged breach of standards of the mediator. Now, these refer to practice standards, but of course, training, right, is what leads, it makes us think about who and how we train our mediators, what standards we use to train them, and what standards they have for practice and ethics when they're out there in the world. And I also want to say upfront that personally, I'm not in favor of standardization in terms of standardizing, having a uniform set of training standards or even a uniform set of ethical or practice standards. And that's something we can explore, and I'm happy to debate and be convinced otherwise if we have time for Q&A. Because I think mediation is a very nuanced, a very culturally agile and diverse, innovative process. I think, though, and this is what I'm going to talk about, it's really important to have a common language to discuss and compare how we train and credential mediators, whether we call it accreditation or certification, it's some form, or licensing, it's some form of credentialing that we're talking about. So, I should be able to do it. Okay, so let me see if I can share now. Oh, it looks like it works. Thank you very much.
No worries, thank you. I didn't want to interrupt you mid-conversation.
No, it's great. Let me just... All right, so where did you get this mediator anyway? What sort of standards do they have? The context I've talked about already. Here's an example of what I mean by cultural agility. It's a phrase I like to use. If you think of a chameleon, right, sort of being able to change color and shift. I think mediation is a bit like a chameleon, right? If you think, this is just one example, right? If you think about mediators, are you thinking about an insider mediator? Somebody who knows everybody and knows the conflict, because that's going to be the most useful sort of person? Or are you talking about an outsider mediator, someone who knows nobody and who isn't familiar with the specifics of this particular dispute, because that's going to be more neutral? Which brings to the second point. Are you more interested, or are you focused on a neutral, impartial mediator, or rather an omnipartial mediator who's on everybody's side? Are you more focused on maximizing party interests, individual party interests, or even maximizing group interests? Because that might not always sit well with neutrality, at least in some definitions of that term. And certainly some research shows, and my experience has been, that many particularly inexperienced mediators can hide behind the veil of neutrality rather than jump in when they see a sort of an ethically challenging situation, a power disparity that perhaps is impacting one party's capacity or ability to make a well-informed decision, right? Are we talking about a party-centered process, or one that's more mediator-centered and guided? Are we talking about individual self-determination or consensus building? Culturally, are we talking about a high context space or a low context space? and how important is confidentiality. And my view is that all these things can be okay and all these things change. And even if you use the same words for training, and if you standardize, people will still interpret it differently, which is why I think blanket standardization is not the way to go. So in terms of a common language, I like to think of 3 elements, and some of the previous speakers have covered this already, which is great. So the first thing is, if you're talking about who gets to become a mediator, who gets to be in the club, first of all, you've got to ask who's eligible and who's not eligible, right? Is it worth me even doing a course if I'm a teenager and in the Philippines I have to be 30 years old, or in Russia I think there's also an age requirement, I can't recall. In Austria I think it's 28. I mean, a number of countries have age requirements, for example. Some jurisdictions have requirements that you need a university degree, for example. So what's the eligibility requirement? Some jurisdictions say you have to be a lawyer, some jurisdictions still have that requirement. Others say you cannot have a past criminal conviction. So that's step 1. Step 2 is, what do you have to do to attain this standard to be a professional mediator? And that's what we tend to focus on all the time. And it's really important, right? What is the knowledge, the content, the skills that you do? And we've heard about, which is really important, what content, how long, and how is training conducted. But then beyond that, I can see now, if you're looking at my screen, I need to move everybody's picture here. Sorry, everybody, I'm moving you away. We need to think about what requirements are there then, once we're mediators, to maintain that standard. And here we're often talking about continuing professional education, but also are there requirements that you have to do a certain amount of mediating every year or every few years? And what happens if the field's not well developed? Is that really fair? Are there alternatives to that? Right, so I think if we can get a conversation going around these 3 elements, right, we're in a much better position to engage and compare and contrast. Because while from a pedagogical point of view, the teacher in me might have a particular point of view of what's ideal, right? The pragmatic policymaker in me says, it's just, you're not going to get everybody to agree, right? But let's compare and contrast so that we understand what we're buying when we buy a mediation credential, right? When we pay for someone to train us, we and also users and consumers. Now, I'm just going to give you, because I think our time is short, so I'm just going to give you a few examples. So I've talked about eligibility. Let me just say a few more words about attaining the standard. Traditionally, there's been very big differences between civil law jurisdictions and common law jurisdictions. And I think nowadays those differences are less, but they're still there. And I think we saw this with the presentations from Russia and Europe, and also the comments that, well, 20 hours or 40 hours is not going to get you there, right? And again, the pedagogue in me says, you're absolutely right if you're starting from scratch. So civil law jurisdictions have typically taken a very different approach, right? Up to 400 hours training in some jurisdictions, really sort of a multi-disciplined approach, requirements for supervised mediation before we let you go out on real people, etc. There are also differences, of course, and we've seen this also in the previous presentations. Are we talking about a general mediator or specialized mediators? And there's a lot of differences there, particularly when it comes to family mediation, but not only. An interesting thing which some jurisdictions are doing, and I personally think this approach is interesting, is they're saying, look, this is a developing profession, so let's not legislate all of the details of credentialing, right, of how many hours you need to train. Let's leave that to the profession, right, particularly if you've got well-developed institutions in your jurisdiction. But in our legislation on mediation, let's recognize those premier industry organizations, right, without telling them what to do. Now, I think this bell means that I have to stop. Is that right? Yes. So I will stop. I'm sorry. I've heard it twice. And so one example happens to be Singapore. I'll just end on this example, which I think is an interesting one. The Mediation Act in Singapore says this applies to local and international mediations. But if you want this act to apply to you and have all the privileges and protections of this act, then you have to use an approved mediator or an approved jurisdiction. You'll find these in the schedule to the act. But who decides, right? The minister will approve it, but the actual, the determining the content is done by the industry, right? By the organizations. And I think that's a sort of a nice approach to standardizing, but still giving flexibility. All right. Thanks, everyone.
Thank you. Thank you.
Sorry.
Quite an enlightening suggestions. And I like little flexibility in what you do, and that is appreciable. Now I would reserve some questions a little later, with your permission. And I invite now Shiv Kumar, the 50-year-old director and actor and video presenter, and our lawyer in Bangalore, running a law firm by name Murthy and Kumar, practicing in all branches of law, at several consultative groups concerning Right to Information Act, Women's Empowering Group, Consumers Care Society, draftsman of Redressal of Grievance Bill, involved in Elders Protection Law, certified mediator since 2007, mediation training by James, US Department of Commerce, master trainer in Bangalore. I invite our senior lawyer, 50 years standing, and a mediator, mediation trainer, and a master mediator and master trainer in Bangalore and Karnataka region, and most popular mediator we have in Karnataka. I invite Shiv Kumarji to present his views. Thank you.
Thank you. Thank you, Niranjan. Can I share my screen?
Yeah.
Yes,
please.
sir, you can.
Thank you, Niranjan, for that lovely introduction. But then you have emphasized so much on the age factor. I wonder whether it has any hidden meaning behind it. I'm not sure. But I do not want to go into that issue at all. Let's see how we begin. Somebody has to help me. How do I start from the beginning? What do I press? Can you see this slide?
No, we can't, sir. I think it's because
Not yet.
PowerPoint presentation isn't right in front. That has to be the primary screen. It would probably help if you click on the stop sharing button and then start sharing again so that the correct window comes in front.
Working here. There's something not working here.
We can see it now, sir.
It's fine, sir.
We can see it now.
It tells me my internet connection is unstable, just the way I am. Okay. My presentation is all about trying to arrive at a global syllabus for training in mediation. I begin with a caveat that I may or may not succeed, but I do believe that we could at least get the process of thinking started so that if not now, a few years later, we could think of some form of standardization in the mediation process. Yesterday, at the keynote address, Justice Chandrachud talked about social justice through courts, through the adversarial process. He also took us through and alerted us to the fact that the platform for achieving social justice through the mediation process and through the ADR process was a far more effective and a broad-based platform to achieve social justice. But while talking about that, he cautioned all of us about two things in particular. One, he said that in the process of achieving social justice through the mediation process, because it is a wider platform, be prepared and be cautious that you don't promote gender hierarchies or promote power imbalances. This was the question of gender hierarchies with the reference to particularly the family disputes, the divorce cases, the family matters that were referred to mediation, and the issue of power imbalance related to labor matters, where there was a perceived imbalance of power between the management and the labor. He also cautioned us that because mediation pursues the goal of social justice, be careful that you do not promote a culture of impunity. Now let us understand that social justice is a global concept. It is accepted by practically all the civilized democratic countries of the world. The courts have the power and the authority, both statutory and constitutional, to enforce that social justice through the adversarial process. Now, let's come to mediation. The burden that has been cast upon mediation after the keynote address yesterday is to tell us that mediation and ADR is a process which must recognize social justice, must work towards achieving social justice in mediation, but without authority or power. The critical distinction here is that in the adversarial process, the courts can enforce social justice. But minus that authority and without that power vested in a mediator, the resultant burden on mediation is that much more. So if we are carrying on our shoulders the burden of ensuring social justice, what are our tools? The only tools we have in our armory is our training, is the amount of knowledge that we possess, is the amount of skills that we possess. And therefore, the first submission would be that we need to review training in the context of social justice, which is accepted today not only domestically, but on all international platforms which believe in democracy and free society. Keeping this in mind, I would begin by saying that we need to redefine training to include standards for pre-training protocol. All this has been already dealt with by the previous speakers, so I'll just read through this. What do we mean by pre-training protocol? It means we need to identify standards, prescribing eligibility norms. We need to have evaluation norms to test ability and aptitude for aspiring mediators. We need to have evaluation norms for during the training and after the training. And most important, we need to have a constant monitoring performance for post-training. This is how I would redefine training, rather than merely saying that you sit at a table for 40 hours or 80 hours and get trained in the mediation process. All of us, I'm sure, would agree that training comprises a learning process. And in the case of mediation, this learning process comprises two components. One is knowledge and one is skill. Knowledge obviously comprises of theory. We look at theory of mediation, the jurisprudence of mediation, the elements of mediation, the principles of mediation. There are multiple words that are used. This knowledge is intangible. Knowledge is most often factual, it is conceptual or procedural in relation to mediation. And importantly, this knowledge is acquired from a trusted source. And this source invariably is either a trainer or a training institution. That is how do we define skills? What do skills actually do in the training process? Skills address capability, capacity, productivity, performance, and decide the competence of an individual to be a mediator. It actually postulates the performing or doing of something rather than the knowledge. It relates to ability to apply the theory in knowledge with the object of attaining a desired result. It means that we acquire a hands-on ability through the trial and error process. It also means that you acquire or enhance this ability through innovation and simulation. Now, keeping this in mind, let us look at what is the Indian landscape insofar as mediation is concerned. We have two kinds of mediation in India. One is the court-annexed mediation, and other is the non-court-annexed mediation, which we commonly refer to as private mediation or mediation in the private space. The court-annexed mediation is controlled by the Mediation, Conciliation and Project Committee, commonly known as the MCPC of the Supreme Court, and by the Legal Services Authority of each of the states. Court-annexed mediation simply means the cases that are pending in a court of law are referred to the mediation process of the mediation center for a possible resolution by applying the principles of mediation. The qualifications here prescribed are that it is meant only for advocates with 15 years of experience, or judges, retired judges are entitled to be mediators. The training content for court-annexed mediation, including knowledge and skill, is decided entirely or prescribed entirely by the MCPC. The training that is afforded for court-annexed mediation by MCPC is 40 hours. The trainers who give training or afford training are certified by the MCPC. Mediators are required to go through a certain number of practical mediations before they are certified as court-annexed mediators. There are no training costs. Selected advocates, both in the metropolis and in the districts, are picked up, are selected. We don't know what is the process of selection, but they are trained free of cost by the MCPC. They are not charged a fee. And in respect of court-annexed mediation, several high courts, in fact, almost all the high courts have framed rules which govern not only the process, but also prescribe the kind of training that they should have gone through before they can be certified as a court-annexed mediator. Let's move to the private mediation space in India. In India today, we have multiple individual and institutional players which offer training and certification, both physical and online. Practically every city has a training entity. It could be a corporate body, it could be an LLP, it could be an individual, it could be a partnership, it could be anything. But there are multiple individual and institutional players in the market today. The training that is offered in the private mediation space is not restricted to advocates alone. In fact, BIMAC itself has trained chartered accountants, we've trained doctors, we have trained insurance guys. So it is not restricted to advocates, while the court-annexed mediation is restricted only to the advocates. The number of hours that are required to be trained in the private space range from 40 to 50 or more hours. We have definitely not reached the 100 or 120 or a 240 hour training, because I'm very, very skeptical that if you want to train mediators in India and you tell them you have to go through a process of 140 hours of training, we will be finding it extremely difficult to get people to undergo that training. Now, the training syllabus or the content in each of these training entities is determined by each entity by itself. BIMAC, for example, we at BIMAC, we customize the curriculum and the syllabus for each target group. We figure out what is the nature of the target group, what is the focus that they need, and we customize that training. But other than that, training syllabus or content is determined by each individual entity that offers training. There are no statutory control there. There is no predetermined content by any authority or any other institution. Now, what has happened in India is that in some universities, the subject of mediation has been integrated into the course relating to alternate dispute resolution. So it forms a separate one of the portions or the segments of a training in alternate dispute resolution at the universities. There are certificate programs that are available in ADR, not necessarily by the universities, but by private institutions. There is also training available in mediation and ADR through distance education, which means you can do it online or you by correspondence. Now, since this year, last year, I think, the Bar Council has introduced mediation as a syllabus, as a subject to be learned by candidates who go through the qualification process of LLB. This is insofar as the educational universities and institutions are concerned. the Mumbai National Law University has for the first time established or started a postgraduate course in mediation alone. It's called an MA Executive in Mediation. It is offered by the Mumbai National Law School University, and the syllabus and the content is determined entirely by the MNLU, because each university is entitled in law to determine the content of the syllabus that they choose. Now, when we talk about training, we must necessarily talk about costs. In the private mediation space, these institutions that offer training in mediation, there are no standard costing mechanisms. It's a free market economy. Therefore, every entity that offers training determines the cost by its own discretion. Now, at this stage, there are two points that I would like to focus upon. One is that in India, there is a perceptible urban focus on mediation. Every institution that is possibly training media advocates or others in mediation, the focus remains on urban areas. We have not yet devoted the kind of time and attention that is required for mediation to pick up space in the rural areas. Second, the previous speaker did mention both, I think, in Russia and in other jurisdictions. You have constantly referred to them as a profession. Mediation has become a profession. In India, we are still in a nascent stage. We are trying to make it a profession. And therefore, if we are going to ultimately treat mediation as a professional service or a professional occupation that people can get into, the need to have a standardized training program or standardized parameters for training, I think assumes a great amount of importance. These are all submissions only for discussion. So how do we determine a global syllabus? Let's look at standards. As we said earlier, to identify prescribed qualifications for mediators could be globally acceptable, globally laid down. Objective norms for evaluation during and after training, those could be universally acceptable. Objective norms for assessing aptitude and competence of potential mediators can also be globally determined. Objective norms for monitoring performance can also be globally determined by a shared consensual process. This is not rocket science. To prescribe qualifications or create objective norms for assessment of performance or evaluation during and after training is something that multiple jurisdictions have already done. All that needs to be done is to pool in those resources, arrive at a common acceptable standard, which will make every mediator globally operable. So that is insofar as the global syllabus is concerned. Now, let us look at the global syllabus for training. I would submit that we need to establish a harmonized balance between theory and skills. My experience at training has been limited, of course, to the Indian subcontinent. The focus has been more on theory. The entire knowledge transfer relates to the theory. I agree that there has to be, I concede that there must be a certain basic amount of theory, the fundamentals, the concepts, the jurisprudence of mediation is essential. But we need to harmonize the balance between theory and skills and not let it become a lopsided process by which we are constantly learning theory. Therefore, a predominant emphasis on skills is what is important than bulk knowledge. I do not think there is a difference of opinion that mediation is essentially a skill. It's an art. It is not book knowledge. It is not bulk knowledge. It is an acquisition of a certain feature or a certain skill of how to deal with people. How do you determine what the response or reaction of a person is? How do you assess a person? What are the skills? Let's look at negotiation skills, communication skills. These are skills that can be imparted. with or without bulk knowledge. Certain amount of theoretical knowledge will be required, but my emphasis on saying let's move away from sheerly bulk of knowledge, sheer weight of theoretical knowledge. There must be, according to me, if you want to standardize and create a global syllabus, a focus on quality in training rather than on quantity. And the most recent requirement will be incorporating social justice norms. We need to draw upon global experience to develop knowledge and skill content. We need to develop models for experiential learning. We need to provide for cultural, social, language, and attitudinal differences that will go into making this a globally acceptable training module. We need to distinguish between academics and practitioners. This is a personal opinion I hold, that if you are going to train academics in mediation, bulk knowledge is fine. But if we are in the process of training practitioners in mediation, our focus must shift from theory to acquisition of appropriate skills. And finally, that you must create a trusted source for knowledge and skill. This has to be some kind of a central bank of knowledge, which is a trusted source. What, however, cannot be standardized, ladies and gentlemen, according to me, is the tools and methodology for training. These are individual. These may be determined by the kind of society you stay in, by social ethos, by cultural ethos, by language differences, and so on. So tools are entirely out of standardization. Styles of training are individually dependent on each person. You may not be in a position to standardize, and you must take into effect the fact that standardization is not possible when there is a large impact of cultures and social norms being in the picture. I would therefore close my submission by saying that we are ready to standardize training. We have same content theory globally. There is no change in the jurisprudence of mediation. No jurisdiction will say that mediation is not voluntary. We all agree that it's voluntary. We all agree that it is party-centric. We all agree that it is party autonomy. That will not change, but the skill may change. And therefore, my submission is that we are ready to have a standardized training protocol. Thanks. Thank you so much.
Thank you, Shivakumarji. You have elaborated the Indian landscape of mediation very well. I personally feel that in India, mediation should become a full-time profession, which at present we mostly find that lawyers do mediation as a part-time job. And there are, of course, in South India and in North, there are a few full-time mediators. But for a mediator to start his practice independently in India is likely to take some time. And therefore, in a very few minutes left, my fundamental question to Natalia ji is, how did mediation grow in Russia? Like it has grown in USA and other Western countries and Australia very well. Now it has become an independent profession by itself. But in order to make mediation a full-fledged profession, what is advised and how much time it took to the established countries where mediation has become a professional game, how much time it took for them, and how did mediation grow in Russia and in Western countries? I understand in USA also, it was started in early 1960s or 70s. Whereas in India, it is comparatively a recent phenomenon. And therefore, we are now looking at a time when mediators can make independent living by becoming professional mediators. Would any of our panelists can explain how did mediation grow in the countries where it is already established as a profession today?
May I start?
Yes, please.
Thank you very much. It was very enriching to hear other speakers on the subject. You know, Russia is a very specific country. We have it as a profession legally, but it does not mean that you may make living with it. So in fact, you may not. That's an additional skill you use as a lawyer or another specialist. And I think that we are happy enough to have only this mediation law and no detailed descriptions what we must do, how we must act, what documents we must have, since our parliament is sometimes called a crazy printer. So they are printing 100 laws per week, for example, just like Italians. We are most likely Italians, you know. And it took 10 years for making this step into the profession. And now we have some tendencies to revise completely the law on mediation. And hopefully it will be done with the participants of mediators, which is not, we may not be sure of that, but we are ready to protect our field of experience. And, you know, everything depends upon your connection with the courts, really. If they recommend you, and if you have persuaded them that mediation is useful, if you have persuaded the lawyers, you've got the clients, and it works as everywhere in the world, I believe. That's why we, as you have seen with Laurence, it's the same thing. We work on the same field. What are the standards? What we are expected to do? What is the mutual recognition? Where to find the mediator? It does not mean that now we may work, so we may live with it, but we strive to. And I think that it will take another 10 years. It is the best prognosis, taking into account COVID and all these things, to really develop it. Thank you.
We have so many questions arising out of presentations by all learned speakers. Unfortunately, we have almost no time left today to this evening, and I would seek permissions of all the panelists to allow me to write to you and ask some questions, which probably in this short time, in this introductory speeches, it was not enough to ask questions. And therefore, I would wind up this session by thanking all of you. You are so kind enough to spare your wonderful time, and particularly Nadja ji has been kept awake in Singapore. It is too late in the night, and we thank you for sparing your valuable time, all of you. Lawrence, your presentation was quite appreciable. All of you have done well, and I thank you very much. I thank BIMAC for inviting all of us to this wonderful exchange of views. I wish we had more conversation left today. Unfortunately, we are many speakers and we have less time, and therefore kindly excuse me that many questions which I have in mind, many other people have in mind, are left. They could not be relayed to you, and therefore kindly permit me to write to you and ask these questions for BIMAC to circulate around to all. Thank you very much. Thank you all.
Thank you.
Thank you,
everybody.
Bye.
Bye.
I would request you all to let me have your telephone number so that I can contact you and be more friendly to know more things from you.
Okay, thanks a lot.
Thank you, everybody. That indeed was a very insightful and educative session. I'm sure we all had a lot to learn, unlearn, and relearn. And we also got to learn about the different mediation training programs offered all across the globe. Thank you so much for that. On behalf of BIMAC, I extend my heartfelt gratitude to our lovely moderator, Ms. Niranjan sir, and all the speakers for accepting our invitation and being a part of this international conference and making it a fruitful event. Thank you so much, everybody. I request all the participants to take a wellness break of 5 minutes and rejoin at 8:26 p.m. And we shall be heading towards the fourth and the final session for today. That is on promoting mediation, role of government, courts, and institutions. And at this point in time, I would also like to hand over the floor to my colleague, Ms. Akila Rajendran, who will be taking it forward from here. Thank you so much, everybody. Yes, ma'am. 5 minutes break. At 8:27, we could start.
Mr. Joy, on mute.
Still on mute. Okay, can you hear me now? Is it?
Yes.
You're audible.
Thank you. Good evening, Judge. Nice to see you, Mr. Priya. Nice to see you on the same panel, Mr. Sri, and everyone else. Thank you for inviting us. How do we take this program, Judge? How do we do this session? What's your thoughts on this?
Hello, sir. Hello, sir. I'm Akila Rajendran.
Yes, Akila. Hi.
So we have a 5-minute break, and after this, we'll be resuming our session, sir.
I see. Okay. I've got my colleague that's come on board to help me with the uploading of the documents. He's there as well.
Okay.
Okay, great. Thank you.
Hi, Joy.
Hi. Hi, Thiru. Mr. Thiru. How are you?
Doing well. Good evening, my lord.
Good evening, Thiru. How are you? Excellent. It went on 3 sessions.
Yeah,
thank you.
It was good. It was fantastic. It was quite good. I was on it since it started. It was very good. Very well done. Thank you.
Yeah. Welcome, Mr. Shekhar.
Good evening, sir. Good evening.
Good
Thank you so much for having me here with all of you. All of the learned people and just trying to learn something. That's all I would say.
Aren't we all?
On a subject which there is no precedence or there is no legal authority. It is just a question of trying to navigate something and learning something. That's all I would say. Of course, when judges and the lordships are here, you always get what I would call elucidated or thought-provoking lordships. That's more important. Because the lordships nowadays not only implement the law, they decide the law, they direct the government. That's more very good development from a legal perspective. So
that's right.
That's gone are the days where the lordships just read the law and implement the law. Today, the lordships direct the government to do that. So in a way, it's good from a mediation perspective also, particularly in India.
Yeah.
Hi, Priya.
Hello, sir. I hope I'm audible to everybody if I'm right.
Loud and clear, yes.
Thank you.
You.
Sir, only one thing to Lordship. I am not having any PowerPoint presentation, sir. I'll be just speaking for 10 minutes as directed by Mr. Thiruvengadam. I don't have any PowerPoint presentation, so pardon me for not having a PowerPoint.
When you have the power, you don't have to have the point.
I'm very sure you have a lot of powerful points, sir. So.
No, this is very topical, sir. Lordship can elaborate, particularly in the recent controversy on the international arbitration contest coming on Vodafone and King. The mediation is an important point because, unfortunately, as Lordship is aware, the Indian tax law do not have any conciliation or mediation process. Despite the insistence by the OECD and the G20 nation, Indian government did not amend the law. Had there been an amendment, then this sort of fiasco would not have been there for the Indian government. Probably there's a sense of opening for the government's lordships.
No, we have made representations to the Ministry of Finance to bring in mediation.
No, sir. Ministry of Finance will not. In fact, as a part of Chamber and as a part of Tax Administrative Reform Commission, which was constituted the earlier Mr. P. Chidambaram regime, I was part of the Tax Administration headed by Dr. Patsa Disho. There are exclusively 3 chapters dedicated in that administrative tax administrative reforms only on mediation and arbitration called mediation process for tax. Some of the powers are not keen to do that.
It doesn't confine, this problem is not only to tax, anything to do with the government.
No, at least I could see an amendment in the Companies Act. I'm seeing an amendment in the MSMEs Act, but tax is a major dispute. If you look at it, tax disputes occupy almost significant revenue loss from the government perspective. Other disputes may not have cause a drain on the exchequer, but tax cause a drain on the exchequer.
I need to sign off because now the session has to start. I welcome you all on behalf of BIMAC. Over to you, Akila.
Thank you, Mr. Thiru.
Thank you, sir. Thank you for the opportunity. I'm Akila Rajendran. I am a counsel and I'm counsel in the Madras High Court, and currently I'm a government advocate. I have been a practicing lawyer for the last 10 years, and I'm also a mediator under the BIMAC. So I'm very glad to have this opportunity, and I'm extremely pleased to meet all of you. And the last couple of years, the last couple of hours has been extremely intellectually stimulating for all of us. We were very happy to hear such informative sessions from such stalwarts in the profession, and I'm very happy to introduce all of you for the next session. I'm really hoping that the next session will be as enjoyable and as informative as the others as well. So we are in the last session now, that is the session 4. And the topic that we are going to be dealing with is promoting mediation, role of the government, courts and institutions. The moderator for this session would be Honorable Justice S.R. Banurmat, and the speakers are Mr. Joy Wilson Appukutten, Mr. K.R. Shekhar, and Mr. Priyatha Dhamaj. So let me elaborate a little bit on our dignitaries for the session now. Honorable Justice S.R. Banurmat, he started his practice in the year 1979, and he predominantly practiced in both criminal as well as constitutional cases. In the year 1990, he was appointed as the additional public prosecutor, and thereafter in 1994, he was the state public prosecutor. In the year 97, he was elevated as the High Court judge in Karnataka. He dealt with a lot of important and famous cases, including the Hasina case, which is the acid victim case. The Supreme Court designated him to monitor the mental health of the citizens of Karnataka, and he is also the founder president of the Bangalore Mediation Center. He became the Chief Justice of Kerala in the year 2009, and he retired in the year 2010. Subsequently, he was with the Maharashtra Human Rights Commission till 2018, and currently he is the chairman of Karnataka State Law Commission. So a warm welcome to you, sir. We are very happy to have you with your lordship, and we are extremely happy to looking forward to your session, my lordship.
Thank you. Thank you, Akila.
It's my pleasure, sir. It's my pleasure, sir. Moving to our speakers, we have Mr. Joy Wilson Appukutten, who is a leading lawyer in Malaysia. He is a barrister at law and is an advocate and solicitor of the High Court of Malaya. And he is a non-practicing advocate and solicitor in the Supreme Court of Singapore. He deals with civil, banking, corporate, and commercial litigation. He is a qualified mediator and a member of the Malaysian Mediation Center. And I would like to move to Mr. A warm welcome to you, sir. Please, we're very happy to have you here in the session, sir. I'm keeping my introduction very brief because I understand that this is the last session and it's been a lot of time already. So pardon me if I've missed out on any of the details, but I've taken out the most important details, and I welcome you all very heartily from the bottom of my heart, sir. And our next speaker would be Mr. Priyatha Dhamaj. He's an attorney of law, and he did his law under the Sri Lankan bar in 1994. He's practiced in civil and criminal in both original and in the appellate courts. He's a graduate in business management, and he's a qualified company secretary. And he's also a mediator from our BIMAC Institute, and he's a member of Human Rights Resources as well. A warm welcome to you, sir. And finally, I move to Mr. K.R. Shekhar. He's a leading attorney in the Deloitte private practice for Deloitte India. He's been there for the last 30 years in a niche portfolio of taxes and corporate and international taxation, inbound structuring and controversy management. He has dealt with various tax cases, and he has authored several tax books as well. He's a member of the NASCAM, ITROF, and the Bangalore Chamber of Commerce. He's one of the leading tax advisors in Bangalore. We're very happy to have all of you on board, and we're looking forward to an excellent and intellectual session, sir. And I thank you,
Akila. Thank you, Akila, thank you so much for your kind words. Thank you so much.
I've kept my introductions very brief because this is the last session, so I wanted to stick to the timing which Mr. Thiruvengadam has given me. So I hope I stuck to the 3-minute timing that you gave me, sir. So we're looking forward to start our session, sir.
Okay. Hello, everyone. Once again, It's a long day or night for many of you participants in this conference, and thanks for waiting to be part of this last technical session. As Vice Chairman of BIMAC, I sincerely appreciate your interest and commitment to the cause of mediation. We have with us eminent speakers, Mr. Joy Wilson Apukuttan, advocate, solicitor, mediator, Malaysian Mediation Center, Malaysia. Then we have Mr. K.R. Sekar, Chartered Accountant, Partner Deloitte Haskins, President of Bangalore Chamber of Industries and Commerce, and member Indian Board of International Fiscal Association of India. Then we have Mr. Priyanta Gamage, advocate, arbitrator, mediator, commissioner of Legal Aid Commission, Sri Lanka, chairman, Sabragama Zonal Task Force on Reconciliation Mechanism, Sri Lanka. Friends, if we go by statistics so far as India and Indian courts are concerned, with which I am associated for the last more than 40 years, India, there are around 158,000 cases pending in the Supreme Court and around 45 lakhs in various high courts. We might lose our account if you search for district courts. Why I'm mentioning is because of the importance of today's topic, that is promoting mediation, role of government, courts and institutions. In India, in most of the litigations, around 70 to 80%, the government is party one or the other side. And litigations are pending many times more than 5 years, 10 years, or 15 years. By this process, most of the time, development programs get delayed or stuck inordinately, but also the cost of the project, which reflects upon the taxpayer, and litigation expenses also increase. For example, if a land is to be acquired, a large extent of land for certain projects, it cannot take possession and begin the development work immediately unless compensation is paid. Then there are disputes raised as to the ownership, entitlement, and the quantum of the compensation also. Though there is elaborate special law, prescribed detailed procedure at every step of acquisition, but finding some or the other loopholes of the law, the action is challenged in courts, and considering hierarchy of the courts, the issue is locked for decades together. Thus, not only project is stalled, but cost goes higher with every passing of the year. Similarly, delays occurs in service matters, and as Mr. Sekar was mentioning regarding tax issues. As such, courts at every level are being burdened heavily with backlogs, and for want of getting early relief, even the citizen has to suffer. As such, the only solution which I find is go to ADR, that is alternate dispute resolution mechanisms like mediation and arbitration. So far as law is concerned, in August 1988, the Law Commission of India, in its 129th report, recommended that mediation should be a part of alternative to urban litigation. Similarly, the Arbitration and Conciliation Act 1996 came into effect recognizing conciliation as ADR mechanism based on unilateral model law. We need to remember that unilateral was using the term conciliation for mediation until it changed terminology with the advent of Singapore Convention on Mediation. Section 69 of the Civil Procedure Code, which was amended in 1989, came into effect in 2002. The amendment gave disputants in civil proceedings the option to choose any one of the ADR options, including mediation. In fact, the High Court of Karnataka, under the guidance of the then Chief Justice, C.D. Joseph, who is incidentally the chairman of the BIMAC also, was the first Chief Justice in India to start court-annexed mediation under the name of Bangalore Mediation Center. Incidentally, I was the first president of the BMC for a couple of years. And Shri Thiruvengadam, the director of BIMAC, was one of the first initially trained as mediator and later was trained as master trainer to train the mediators. I must say, court-annexed mediation was successful. Today, there are more than 2,500 accredited mediators across. But my experience shows that the disputes between individuals can be solved by mediation very easily. But it is difficult when it comes to individuals versus institutions, especially government and government companies. The main problem is taking responsibility of settlement. Because of hierarchy in a given government department, no one officer is willing to take decisions to settle through the mediation. Similarly, ad hoc arbitration is also non-institutional arbitration. Unfortunately, at times it gives room to complain of undue influence and collusion, so far as government is concerned. For example, in a construction contract dispute, the contractor claims 100 crores, to which the official cannot agree. The contractor raises a dispute and refers it to ad hoc arbitration. In the arbitration, some of the officials may not, but collude, that is alleged, with the other parties, and the proceedings are deliberately not appropriately defended. The government may suffer an award with interest. Ad hoc arbitration involves lakhs of rupees as arbitrator's fee payable per sitting. The number of sittings is unlimited and the cost is enormous. Allegations do exist that arbitrators share their fees with the lawyers and all the government contracts. So what should be the alternate for this? The large pendency of the cases before the court, or even a problem with the ad hoc arbitration. The best way is to adopt mediation. Now, a few suggestions I have considered during your discussions. All government contracts should have an arbitration mediation clause compulsory. No doubt, presently most of the contracts have arbitration clause. But if mediation is also introduced, it is well and good. Now, all disputes shall be referred to institutional, not-for-profit ADR centers only. So the collusion or whatever underhand dealings should be stopped. The maximum fee payable for an arbitrator to be limited up to the ceiling. The arbitrators are to dispose of cases within time frame. The mediators are presently there is 6 months, I am told, but still, even mediation also that can be done. The mediators should be different from arbitrators, but being the same ADR center, the arbitrators can work as mediator. Then when the parties arrive at settlement, the mediator sends the settlement agreement to the arbitration tribunal for confirmation by the parties. Similarly, it can be arranged to be sent to the court with court seal. Now, government has to approve the consent terms before the arbitration or mediation, and approval by not less than a person in the level of secretary should be obtained so that everything is transparent. And officers are also to be protected. So these are a few of my suggestions. Now let us open our discussion and let us hear the experience of Malaysia, Sri Lanka, as well as Indian prospects from Sekar also. I call upon first, I think Mr. Joy can start the discussion.
Thank you, Judge. Thank you for the invitation. Thank you all for BMAC for inviting me, Mr. Thiru especially. It's a pleasure to be on board. It was very enlightening what you had to say, Judge. You're talking about the government having to be a party to substantial litigation, and also suggesting the compulsory mediation clause in certain matters through the government process. Some of the panelists who spoke earlier actually had come up with some good suggestions as we speak on this idea of promoting mediation. You know, at this juncture, mediation seems to be the last resort, instead of being the foremost in the forefront of everybody's mind when they look at dispute resolution. Unfortunately, it's not given much credence as opposed to once one puts their foot into court. So let me just share what's happening in Malaysia and then see how we progress from there, and then what my proposals would be for promoting mediation. In the Malaysian context, if I can just go to the next slide, you'll see that, you know, we are in this pandemic scenario. We have seen these the difficulties we have in administrating justice through the court process. Court cases are postponed, adjourned because of the pandemic, lockdowns, and so forth. So I'm taking you back before this the pandemic situation. You'll see that in the Malaysian court systems, you know, in the civil cases, we've got different levels of the courts, from the lower courts with the magistrate sessions court to the higher courts, which is the High Courts, Court of Appeal, and the Federal Court. You see the figures that are outstanding, and the magistrate courts are 37,000, sessions court 16,000, 56,000 in the High Courts, and Court of Appeals about 4,600 over in the Federal Court. That's on the civil cases. Now we look at the criminal cases. On the next slide, you will see similar scenarios of extenuating circumstances for criminal cases. But when you look at the next slide, post the COVID scenario, the civil cases have not really jumped up substantially in terms of its procrastination in the court process. Otherwise, it has actually maintained comparatively. But you see that the impact on the criminal cases on the next slide, you'll see that the impact of the criminal cases have escalated. And as a result of this escalation, it has actually evolved into a situation where, if you look at the next slide, the rise on litigation and the disposal rate in the court process pre, during, and post the COVID-19 pandemic. So you see the backlog that's transparent here. But overall, in the Malaysian context, you will find that the civil cases have actually progressed. If you look in the context of mediation, the mediation process started off in Malaysia relatively recent. We were looking at about the year 2010. So when it still started evolving in 2010, the Chief Justice then took an initiative to get along with the Malaysian Bar Council and the other stakeholders to develop the mediation process. What was then subsequently became the court annex mediation. That evolved and substantially supported a lot of the processes. In the period of 3 years, from 2011 to 2013, it was something like 60% of the cases in the court then were referred to mediation. And there was a success rate of about 40% at that material time. So there was a progression, and that was good. Matters were resolved amicably and so forth. So over time, legislation started to be introduced. We had in 2012, the Mediation Act, it's in the next slide, which was introduced in the Malaysian arena, and that helped facilitate and to some extent, although it's not compulsory or mandatory, it was a voluntary basis to encourage parties to consider mediation. And of course, so opposed to that, then the rules of the courts were changed and amended, and which allowed courts themselves to direct parties to consider mediation. So that's how the court annex mediation became more prevalent. Then you had the practice direction by the Chief Justice at material time, which made it mandatory in what we call accident cases, personal injury and so forth, in accident cases for mediation. So that also assisted in the facilitation of completing disputes. So we have those processes that's taken place and has have evolved in the Malaysian context that has assisted in the mediation process. And you see the development of it, and that is perhaps one of the reasons you'll find that in the Malaysian context, whilst we had the pandemic, whilst we had the COVID-19 scenario, whilst we had the lockdowns and all sorts of other anomalies that took place that prohibit us from actually going through the court process. The mediation process actually assisted in resolving much of the litigation. So in the Malaysian context, you have two types, the court annex mediation, which is what I just described. And also you have the, what you call a private mediation, in the sense of pre-court processes. So we have the Malaysian Mediation Center, which I'm a member of, and we have those in the securities industries, which is called SIDREC, Securities Industries Dispute Resolution Centers, to deal with disputes arising from the security industries, shares, and so forth. Then you have the industrial relations, conciliatory for labor dispute matters. And you have the central bank financial mediation bureau for disputes with banks and finances, financial institutions and insurance. Then you have a dispute resolution process in the Inland Revenue Board. Party was a dispute over their tax or scenarios and all that. They have this avenue that's available. So we have a variety of mediation processes specifically for specific industries. Not one common area that I will embark on shortly as one of my proposals, and how we develop and promote mediation. Now, moving forward, the focus on mediation is for reconciliation of disputes. One of the speakers that actually, if I can, one of the speakers earlier, I think Ms. Anna Sombold, had spoken about using mediation, where I think in the consumer perspective, where in the US, I believe she mentioned just now, where mediation is used on a time scale period, i.e. for 2 hours. And thereafter, if parties cannot resolve the matter through mediation, it goes automatically to the mediator, who then becomes an arbitrator. So in other words, there is an immediate solution to the matter. If the matter doesn't go to mediation, there is a solution to it to be arbitrated subsequently. So that was one of the interesting development which I just understood to take place from this conference. Now, what are the ways we can actually develop further? Can I go to the next slide, please, James? In this current pandemic scenario, we have a very acute situation. So it entails bringing in the government to the picture to move and develop the mediation process. So in the Malaysian context, the Malaysian government has actually come up with a COVID-19 mediation center. And this is something they instituted sometime in October, November of last year. They have made a qualification to it, and it's restricted, unfortunately, to firstly to a monetary limitation of 500,000 Malaysian ringgit, and to certain industries. These are some of the industries which they have actually limited the mediation process, which is with respect to the construction, performance bonds, events, as you can be explained. I've got to move the tourism, professional services, lease rent, which is a major issue, especially in this current scenario, hire purchase agreements, religious pilgrimage, and credit sales contracts. So these are some of the areas in which the government has actually advocated the use of the mediation process in this COVID-19 era. So what else can the government do? Plenty more. I think the judge had just explained some of the concerns we have, one of which is compulsory mediation on arbitration clauses. And that could be something which they could actually do contractually as opposed to just legislating it. So apart from that, my thoughts are basically, if you look at it, I'm looking at multiple things to be done. Drawing up some sort of common set of mediation standards and code of conduct of mediators. So that will become more efficient in the Malaysian context, as I've explained just now. There are various different sets of mediation centers for specific areas. But if you have a common set of mediation centers and code of conduct, that would go across the board in easier training and facilitation of the mediation process. That goes to the second thing, which is the formation of centralized mediation institutions, so that we have one body. It generates down to specific mediation centers with specific skills. Legislation making it compulsory mediation, perhaps in certain areas prior to filing a dispute. where matters could be resolved, consumer disputes, property disputes, and so forth. Simple matters which can be dealt with immediately between individuals and large organizations. Those kind of things, or perhaps in certain aspects, contractual mediation clauses, as judges has suggested. Education is an important vital element. There is a need to engage with businesses, industries, chambers of commerce, professionals. It is still, mediation is still lackluster in terms of its understanding. It seems to be a failed methodology in terms of usage, unless people are aware of it. So we need to develop it, we need to educate it. And at the moment, the people that participate in the mediation conferences and seminars are the stakeholders, mediators. We need to move beyond that and make sure that everybody participates in this available alternative dispute resolution. If I may also look at the next slide, please, where I have also suggested that we encourage mediation, not just from the legal profession itself, but perhaps we should extend it to parties in that skill and field and areas who better have a better understanding of it. If you want to go through a greater length of understanding of mediation in specific areas. If it comes to merger, acquisitions, corporate disputes, shareholders, so forth, anything else, medical, in fact, medical disputes, construction disputes. We have special arbitrators for this kind of areas. Why can't we have special arbitrators, mediators as well to facilitate? We can start at the university levels with lecturers, professors, alumni, and so forth. These are groups of people. I'm abstracting this idea, this thought actually, which is something which one of our judges in the Court of Appeal in Malaysia, Hamid Sultan, has suggested, which is the Malaysian Court, University Common Court Annex Arbitration, which is available on the website, which I just produced there. So if we engage with the experts, so to speak, in the respective fields, we can then be able to promote the element of mediation wholesomely to all and sundry. So the other aspect I'm also looking at is also, we are at the moment speaking of mediation in the context of dispute resolution. We are in a pandemic era, and there don't seem to be a light at the end of the tunnel, but it seems to be a situation in which we have to engage with. The current scenario limits us in our ability in communication, discussion, and participation. We are now literally doing everything online as we are in this conference. There are a lot of businesses that are failing. There are a lot of industries that are suffering, and there are a lot of parties that need assistance. One aspect in which we can look forward in our mediation processes, apart from looking at a dispute element as mediators, we can also look into resolving and assisting and facilitating business failures. And that is what I'm looking at as we progress in this conference, that we take our level, change the paradigm shift and our thoughts and our ideas from dispute resolution to conciliatory scenarios in which we can assist businesses, finances, and the government to deal with the current pandemic. And it is akin to a restructuring exercise perhaps in some industries, but we can then mediate and resolve the matters between employer, employee, bankers, finances, loan disputes, resolutions, government aids and assistance. We can be there to do that structure and assistance. So how do we do this? We promote the mediation process. We do it internationally, locally, domestically, and wherever we can. And we need to engage with the government, which is the primary beneficiary in this whole exercise. Because at the end of the day, when they support the system, they support the people, they support the industry and the businessmen and the professionals, the employee and the member industry. So they have to lead. They cannot take a backseat on this matter. Second are the institutions. The institutions need to be engaged. The chambers of commerce need to be more proactive. They need to find solutions and resolutions and not just dispute resolution, in resolving businesses that are failing, finding alternatives so that we then can be mediators in resolving the various parties that are engaged in that kind of scenario. We then have the courts. The courts play a very fundamental role in these exercises, because if businesses are failing, financial institutions are going to foreclose, loans are going to be called back, litigation is going to commence. Courts play a major role in developing this to cease this progression into a futility. They will then have to take a more proactive steps in getting mediators to mediate. And when I say mediation, I'm not talking about resolving whatever they have between the court parties, but the holistic approach to deal with it, with the failing industry. So that is where we come in as mediators, with our expertise, our skills, and making sure that there is a holistic resolution to the dispute. So those are my thoughts at the moment, my dear friends. I end here, and I encourage all that we must take this mediation process to greater heights. Otherwise, it's going to be just a back burner to the court process. Thank you.
So you're on mute, sir. And thank you.
Thank you very much, Mr. Joy, for your suggestions and the improvements you have made in Malaysia. Now I call upon Priyanta Gamage from Sri Lanka. Let us hear his experience. Mr. Priyanta.
Yeah, hello, sir. Thank you, sir. And thank you, BIMAC, for this great opportunity and the kind invitation. So mediation is nothing new to Sri Lanka. So I must say, just like in all the other Asian countries, we have had a system outside of court where the disputes could be resolved amicably between the parties. And the particular institution, one of the first known established institutions, is called the Gam Sabha, or the village council. This is something similar to the Panchayat in India. So where people could refer their problems, and mediation could be exercised on that issue. And the Mediation Boards Act number 27 of 1988 was the first instrument where mediation was officially recognized. So under the Mediation Boards Act, the mediation boards were constituted in Sri Lanka, and as of today, there are 839 mediation boards established in the country. And I believe something like 7,000 odd number of mediators are working in these mediation boards. In Sri Lanka, mediation is of four kinds. First one is the voluntary mediation. That is, the parties can volunteer to refer their problem or the issue for mediation. That is voluntary. And the other one is the court annexed, or in fact, this is mandatory mediation. So where there are certain civil claims as well as criminal offenses necessarily have to be referred for mediation before litigation begins. For instance, in criminal cases, offenses with regard to property and assault, trespass. So criminal offenses of this nature definitely have to be and mandatorily have to be referred for mediation. And civil claims also, any claim that is less than 25,000 rupees has to be referred for mediation. That is the mandatory mediation. And the third one is the court directed mediation. The court also has the power to refer certain disputes, even if they do not come under the category of the court mandatory mediation, to refer it for mediation. So, when a matter is, and the fourth one is commercial disputes. Commercial disputes also can be referred for mediation. And there are special mediation centers as well. And once a dispute is referred for mediation, the mediation board looks into that. It is referred to the particular mediation board or center in the relevant area. And the mediation board members are appointed by the Mediation Boards Commission. In fact, the whole administration of the mediation boards is done by the Mediation Commission of Sri Lanka, where there are 6 members, 3 are statutorily appointed and the others are appointed by His Excellency the President. And also the mediation board normally comprises of 3 members. They are also chosen from the area, who they try to select political people as much as possible. So those who do not have any political clout with them, so that they can work independently. So once a matter is referred for mediation and the parties are present, they try to bring about a solution or resolve their disputes. If the parties do not come, then there are about 3 notices are sent again, and even when the 3rd notice is sent, they do not come for mediation. Then the mediation board issues what you call the non-settlement certificate. Then along with that certificate, they can begin their litigation. And the other instance where the non-settlement certificate is issued is where the parties are present, both parties are present, but they do not come to a settlement. So in that event also, a certificate of non-settlement is issued. So along with that non-settlement, the parties can begin their litigation process. So as I said, so the litigation, mediation being mandatory in the court process, there are huge number of cases right now in the mediation boards. I believe as per the last records, the success rate, the settlement rate is at about 62%. There is a serious value and contribution by the mediation boards in Sri Lanka. So, but one of the lacunas in the system is that because there are so many cases before the mediation boards, sometimes it lacks the finesse with which the matters should be dealt with. So as it was introduced, I was lucky enough to come to India and to be trained as a mediator at the BIMAC, and now I'm a BIMAC mediator. So along with the BIMAC, we are trying to bring about improvement or changes, or we want to see what could be done with regard to the Sri Lankan situation as far as mediation is concerned. So unfortunately, as we are all aware, this pandemic situation has affected all our good motives. So let us hope that we would be able to endeavor on this mission once the things are back to normal. So, so this is briefly what the Sri Lankan situation is. And also if I were to point out the exceptions, so even though there are certain civil as well as criminal matters that has mandatory to be referred for mediation, there are exceptions as well. For instance, the matrimonial matters cannot be referred for mediation. And where one of the parties is the state, that matter also cannot be referred for mediation. So likewise, there are certain exceptions as well. So I believe I have limited time, so I'll be very happy to answer if any of you have any questions, please. Thank you.
Thank you, Priyank. It's very nice to hear the progress made, and especially the Sabargama system, zonal system. This was prevalent in India from ancient times. It was called as Panchayat Katta under a tree. five elders used to sit together and decide the disputes, and they had no knowledge of law. But unfortunately, that system is gone. But I'm surprised why these matrimonial reference cases are not referred. In India, especially in Bangalore, we found large success in deciding cases. Of course, we will look into it, what is to be done. Now, because of time.
But if I were to answer that question, sir, if I were to answer that question, one of the reasons why it is not referred, why matrimonial matters or issues are not referred for mediation is there are court-appointed and court-connected family counsels as well as probation officers in every courthouse. So they are specialized in that. And anyway, all these especially divorce matters and maintenance matters and the child matters, our custodial matters are referred to these two institutions. Maybe that was the reason.
Okay. Okay, thank you. Now I call the last speaker, Mr. K.R. Sekar, to speak about his mind. Mr. Sekar.
Good evening, sir. Thank you so much for having me here.
I'm sorry I kept you last because I just wanted to give
no issues. No issues. I'm a great fan of cricketers, so sometimes I'm a tail-ender, and tail-ender will have to take a heavy load sometimes. I understand that. Thank you so much for inviting me and being here with all the lordships and all the eminent legal pundits. I'm not a lawyer. I'm a chartered accountant, so lack of knowledge in the law, if it comes in my presentation, I'm sure lordships will always give another chance to rectify my law. No, the lordships. Coming back, everybody talked about the mediation, and I am proud to say from India, mediation is nothing new in India. Mediation has been in the historical Indian Vedic text or Indian, what we call the Puranas and literature. It is plenty. Go back to Mahabharata, Lord Krishna tried to mediate between two warring factions. He failed. Ramayana, Hanuman tried to mediate between Ram and Ravan. He failed. In Kanda Purana, which is another famous story, which is famous folklore in southern part of India, where Veerabhagu tried to mediate between Lord Subramanya and Surapadma, he failed. So mediation has been part of the Indian text and Indian literature and Indian folklore stories. And unfortunately, I would not like to blame anybody, but we forgotten the Indian system and we started following the Western system. With the result, we moved away from the mediation to the court system and the legal process. With the result, the mediation and the process of the mediation took the back seat. And people who have watched the Indian movies, whether it's a Bollywood movie or whether it's a South Indian movie, you'd always see a rural place, and there'll be 5 chieftains of the rural village with a small vessel on the part, and they give a justice to the rural people for the warring side without knowing the law. But that law, whatever they say, was followed by the rural people. And that is a type of a mediation that still Indian rural people followed. And probably, I believe, I go back to the point which I have a fundamental belief. People who are ignorant, they follow very strictly the words of the elders, words of the seniors who have got a wisdom. People, women, they become educated. They try to find a way by which I should not follow the words of the seniors and the wisdom. And that's one of the challenges in the disputes too, which lead to what Lordships in his opening remarks said, the huge cases pending in the courts and authorities. India ranks 93 out of 113 nations in what we call civil justice. It ranks 66 among 113 countries in case of enforcement of the law. Why we are ranked so low in 93? As Lordship says, predominant disputes are raised by the government, with the government, against the government. And India has got around 28 states and 8 union territories. And each state has got multiple laws. And as a result, the compliance of the law, whether it is a government law or whether it is a private law, has led to a challenge. And everybody wanted some sort of what I would call a award in their favor, not equally or in favor of both. And that is a predominant challenge in making success, the mediation more successful in India. Nobody wants to accept, it's a mindset. I'm sorry, I'm not a lawyer, I'm a chartered accountant. Pardon me for this. Nobody wants to accept a defeat. Everybody wants to have a victory over the others. And that's a predominant problem that comes in making sure that mediation is successful. Another important factor, the way I would like to put it in a matter of next 5 to 7 minutes, is that the challenges, what is the role of the chambers and the corporates and the educational organization should do, and finally the way forward. If I look at the challenges, I'll just take 2 or 3 examples. We have a solid regulatory framework of late coming in India on the mediation. Of course, I would like to have an Indian Mediation Act, like the lines of the Indian Arbitration Act. I would like to have Indian Mediation Act, it should be there. But notwithstanding that, today the companies have got a provision for reference of mediation by the National Company Law Tribunal. And I could see some success in the National Company Law Tribunal because there are a lot of companies through the insolvency proceedings are getting revived. And definitely, I'm sure, had it been in the earlier days, it not have been so success, at least I could see a lot of revival of the corporates under the insolvency law. Second, Delhi High Court, as Mr. Lordships was mentioning, Delhi High Court in its recent survey said that out of 2,892 cases on family case it was referred, 2,172 cases have become successful. Almost 80% of the family case that was referred have been completely resolved. So there is a strong sense of belief and what I would call a buy-in from both the parties to go with the mediation. And that is a very, very important silver lining in the overall mediation. The second important legislative framework came from the MSME Act, where the MSME Act refers for mediation. The third is on the similarly Industrial Disputes Act, which is another important area for the mediation, has got us provisions to make mediation a compulsory. But though we have a law for making mediation a more powerful and more compulsory and more meaningful, yet the parties to the dispute rarely go to mediation. As Lordship said in his opening remarks, though there is a clause in the contract, it should be referred to an arbitration, but there is always a perception that arbitration award is in favor of one, is against the other. Moment you have one against the other, arbitration fails, and that is where the mediation should enter. And to get that mediation should enter, somewhere the regulatory framework should be more, I would not call tougher or stricter, more enabler for parties to refer the dispute to the mediation. In this context, I just wanted to highlight how the legislative framework failed in the case of the income tax. I'll just take 2 minutes. In income tax, though global nation G20 network or OECD have recommended that every country should have arbitration conciliation proceeding in the Income Tax Act, the government appointed under the chairmanship of Dr. Patsa, the show on Tax Administrative Reform Commission. One of the 2 chapters, I was part of the member of the Tax Administrative Reform Subcommittee group, where the Tax Administrative Reform Commission recommended a proposal as a part of the Income Tax Act itself on arbitration conciliation proceedings. Unfortunately, the government never implemented it, never took even those amendments very seriously. Rather, somewhere in way back in 1992 or 1993, the Income Tax Act had got a provision for alternative disputes in the form of authority of advance ruling for the foreign companies. A great institution was created with the greatest and noble objective in the mind of not creating the dispute, but settling the dispute at the beginning itself. Unfortunately, today, not even a single ruling of authority of advance ruling has been accepted by either parties, and it is going to the High Court through a writ route. What was originally, the law says it is binding on both sides, but there is a way by which we beat the law and we go to the High Court on the writ route against every advance ruling, whether it is a taxpayer or the government. Now, with the result, and one more challenge arises on the institution is that we have to identify retired judges to preside over the authority of advance ruling, and with the result, the government could not get it. Now the authority of advance ruling has become the board of advance rulings rather than authority of advance ruling. Now a great institution was created for the purpose of resolving the dispute at the beginning, now as coming to the Board of Advanced Rulings created with the Central Board of Direct Taxes. Similarly, in the Income Tax Act, another great objective was created called Dispute Resolution Panel, where a dispute resolution panel was created with the objective of resolving the dispute with the taxpayer and the tax department. But it has become more of a dispute confirmation panel rather than the resolution panel. With the result, the disputes never got resolved. Under the Income Tax Act, 50% of the disputes are by the government with the public sector companies and the public sector banks. There is no need for such a dispute despite various measures are being taken now. The point which I'm trying to put forward here is that if we need to have a successful mediation, the best way is that the government should stop filing cases, the government should stop litigating, and the government should find a way of mediating. And government should be a more enabler for dispute so that parties should follow. And another reason is that in India, going for a legal issue is pretty expensive and nobody can do that, considering the time with the lawyers or the professionals and time, it takes a lot of time. And therefore, it is very important for organizations like chambers of commerce, professional bodies to get into the field of mediation. Today, who talks about the mediation is only few people, though I am proud to say that thanks to my good friend Om Prakash, who is here, Bangalore Chamber of Industry and Commerce entered into MOU with BMAC, and we started training the trainers as part of Bangalore Chamber of Industry and Commerce. Today, we have successfully launched a program of training the people for the mediation. And this is a job which every Chamber of Commerce should do in this country. Second one, people still believe mediation is something like I'm sorry to use the word, it's something like a fixing up. No, mediation is a professional way of resolving the disputes, and it should come as a part of the curriculum. The earlier speaker talked about training, but it should be a part of the curriculum in every institution, whether it's a chartered accountancy, company secretary, ICWA, MBA, because today there is nothing called production, there is nothing called mechanical, there is nothing called finance. Disputes arises in every part of the organization, every part of the dispute. And therefore, mediation should be a part of a curriculum in every academic institution in India, which makes mediation is more important. And last but not the least, the way forward. Law Commission, 129th Law Commission report recognized the mediation as important. All the legislature have accepted the mediation as an important. And family cases have been successful in mediation. But what I'm more keen is that trade disputes are the most critical disputes. And there are mindless penalties, mindless small issues. All those issues can be resolved through the mediation, and government should come out with a framework which enables that every dispute, barring the criminal proceedings, every dispute should have to come through a mediation center or a mediation policy, and it should be more socialized. And with the result, if you do that, then probably there will be lesser disputes that come into that. I just close my remarks with what Nani Palkiwala said in his famous book, We the People. We got too many laws, too little to administer. Too many administrators, too little administration. And too many governments, too little governance. And if we address these points, probably I'm sure the mediation and the efforts taken by the BMAC will become more meaningful in the days to come. And I thank BMAC once again for the opportunity. And I thank the Lordships for allowing a non-lawyer to talk about the subject on mediation. Thank you so much, sir. Thanks a lot.
Thank you, Mr. Sekhar, because we wanted a person from the field itself, not from the legal aspect, who has got practical sufferers. Thank you very much.
Thank you.
I think we have some time. Any questions from the...
Are there any questions?
I think there's one question has come. Why matrimonial is not referred to mediation in Sri Lanka? I think that was answered.
Yeah.
If there are no questions.
So there are no
Sir, can I make only one point, sir, if you permit me, sir?
Yeah.
I had that one, but I did not quote it because of time constraint. For the speakers here, everybody today also you would have read a paper that French government, the Cain Energy has got an order from the French court to attach the assets of the Indian company. for the tax due for the clean energy from the Indian government. Again, it is an international tax dispute. And instead of arbitration, had it gone to mediation, this issue would not have come. And the amount of time that has gone, the amount of tax that needs to go as a refund is phenomenal. Phenomenal from an Indian perspective. I do not know whether the Indian government will have to introduce a Vodafone tax or a cane tax to collect the money and give us a refund, that much of money. Had the government addressed the issue through a mediation process rather than arbitration process, as Mr. Harish Sable said, not to dispute it further, things would have been much better. And that is a pain. As far as India is concerned, 60 to 70% of my tax cases gets resolved, my legal issues gets resolved, and definitely India would not be 93, India would be in top 20 as far as the civil justice is concerned.
Thank you. We hope something can be done. And even in fact, inaugural session, Justice Chandrachud also mentioned about efforts would be taken up because he was also impressed by the work going on. Let us see. Even as a chairman of Law Commission here, I can make now, based on the experience of this conference, I can make certain report also. Let us see how it happens. Okay. Thank you.
Thank you, sir. An excellent round of applause, and thank you to our moderator and to our speakers for this lovely session. It was extremely informative, and it went across all verticals, from the village panchayat system to the Sri Lankan, to the Malaysian, to the Singapore government. So I think it was a lot of knowledge which was packed without a PowerPoint presentation now. So, and I think Lordship reserved the best for the last. So I think we had a taste of everybody's knowledge, which was entirely enriching for all of us. Thank you so very much once again to our moderator, Honorable Justice, and to all our speakers. Thank you, sir. And I thank BIMAC for this opportunity.
Thank you, Akila, and thank you all the panelists.
Thank you.
Thank you very much.
Brings us to the end of our session, and over to Mr. Thiruvengadam for a vote of thanks and for the closing remarks.
Thank you, Akila.
Over to you, sir.
Very much.
Thank you, sir. Thank you so very
much. The honorable speakers, our friend Joy, Shekhar, and Priyantha. Before I go to the render my vote of thanks, couple of comments I'd like to make. You know, I've been a trainer, and every training session I always try to tell, let us not compare panchayat system to the mediation, because panchayat was definitely an adversarial system, and mediation is not the, I'm talking about this. And I also talk about why mediation is successful, because a mediator has to be neutral and impartial. And I always tell that when we talk about neutrality and impartiality and with respect to mediation, we have to earn the trust. The parties have to repose the trust and confidence in the mediator. And I always say Lord Krishna, though he had all the godly powers, the Kauravas did not trust, because they never perceived him to be an independent person, because they felt that he is related to Arjuna. So Subhadra got married to Arjuna. So these are the things which weighs a lot in people's mind, whether should I trust or not. Otherwise, we'd have got a lot of mediation settled. And Mr. Shekhar rightly pointed out, yes, there are a lot of issues which on the tax side could be resolved. But the problem in India is that, as one of my friends said, you Indians sneeze the moment every time you sneeze, you have a new law. Now, again, there's another comment that they made. How did India become very successful in information technology? Though IT came into India in the early 90s, we never had a law that is information technology law in 2000. We allowed the industry to develop, understand, perceive what goes wrong and what can be done. And even now, we don't have a very effective IT Act, because we're still trying to tinker with it. There's an attempt to come out with a law for mediation, which in our perception, many of us think it's too hasty. We'd rather have one law, one single ADR code, which can be composite, than having many laws. We'll have various types of ADRs. There are plenty, but half a dozen ADRs I can think of. We can't keep having law after law. So this particular session has been very thought-provoking, extremely useful, and the input from Malaysia and Sri Lanka is really revealing to us. And of course, what's said by His Lordship also is very, very important. And we have miles to go, and several miles to go. And what I feel is that we need to have these sort of interactions, and BIMAC is meant to support those who want mediation. Any not-for-profit institution wants support. BIMAC is here. We are not competitors, we are collaborators. Let me make it very, very clear. So, friends, all good things must end one time, yet the memories have to stay. Let it be locked down deep in our hearts forever. And whatever we learned should be cherished as a treasure. With that, I thank each and every one of you, all the speakers, all the moderators, my board of governors, especially His Lordship Justice Banurmat, who stayed so late, and Joy must be very, very late in the night for you in Malaysia, and your assistant, Mr. Lee Jinsheng, and my team of BIMAC team, Ramya, Manik, and Mr. Vivek Sharma, and Shri and Akila, for your tremendous amount of support and enthusiasm. And I request all of you to go back with good memories. Thanks a lot, and please remain safe.
Thank you,
Thank you.
everyone.